Maybe please, Your Lordship. Lordship, with regard to supply item number 14, yesterday I have filed one affidavit. I may be allowed to call for it.
May please, Your Lordship. Lordship, yesterday we have circulated a adjournment slip
Huh?
item number. Yesterday we have.
Okay, adjournment slip for item 11.
Yes, sir.
Okay, right. Adjournment prayer has been made on behalf of Dr. A. Sharaf,
Yes, sir.
Learned Counsel for the petition. Accordingly, release this matter after 2 weeks. After vacation.
Interim order, interim order.
Interim order. Interim order to continue till
Obligation.
Your Honor, one read petition is for listing. Read petition civil number 2565 of
21.
16, sir.
Is okay.
May please, Your Lordship, whether I pray for listing of a matter, my lord, pertaining to non-payment of contractual leaves matter.
Huh?
Non-payment of contractual leaves matter. Anything matter before vacation. Go to it. Withdrawal, I think, well.
We have instruction to withdraw as the matter.
Miss
Tindum on behalf of RK Talukdar.
Tindlung on behalf of Miss. How do you spell your name?
TINLUNG Tindum.
You got? Okay. Appearing on behalf of Mr. R.K. Talukdar submits that instructions have been received from the petitioner to withdraw the writ petition.
May please Lordship, I am appearing on behalf of respondent number 2 and 3 for T. Kalita,
Miss, your name?
C.S. Marak.
C.S.
Marak.
Marak
Yes, Lordship.
appears on behalf of Mr. T. Kalita, the counsel for the respondents number 2 and 3. The prayer of the petitions counsel has allowed. Writ petition is dismissed as withdrawn.
Obliged, Lordship.
13.
May Your Lordship, I have instruction not to place this.
Why? Complied with
Yes.
Mr. M.R. Adhikari, learned counsel for the petitioner submits that the order dated 30/06/23 passed in WPC 3880/23 has been complied with. Accordingly, the contempt petition stands closed.
I think one for motion.
License has been restored.
Then,
Then we have.
end of the matter. Okay, right.
Very grateful.
Mr. D.A. Kavyum appears for the petition, while Mr. S.R. Barua appears for the respondent. Number 1.
Number one, DC.
Number 1.
Aninda Chaudhary, DC Walpara.
Mr. S.R. Barua has submitted a letter issued by the Additional District Commissioner, Food, Public Distribution and Consumer Affairs, Golpara, which is to the effect that order number GSG /2024/144 dated 22/11/24 for restoration of the PDS license of the petitioner bearing number PDA 1630/70 has been issued, and that a letter has been sent to the Commissioner of Food, Public Distribution, Consumer Affairs and Legal Metrology, Guwahati, on 22/11/24, requesting allocation of new EPOS device and a fair price shop in favor of the petition. Next para. The contents of the letter dated 25/11/24 issued by the Additional District Commissioner, Food, Public Distribution and Consumer Affairs, Golpara, is reproduced herein below as follows. Take it from here to here. The same is made a part of the record and marked as the next year X. in view of the compliance of the order dated 21/8/24, passed in WPC 1302/2024. The contempt petition stands to.
Obliged.
May I please your lordship? I'm appearing on behalf of B. Gogoi. He instructed me to take 2 weeks time.
Okay.
Instruct-
Miss
M. Das.
M. Das
On behalf of-
appearing on behalf of Mr. B. Gogoi, counsel for the PWD, is granted 2 weeks time to file affidavit.
If
This is
you-
a matter of truth.
I think three.
Where is your records?
They have sent me, I have got one instruction, they sought some more time. But, can it be on the next?
Okay,
Next.
right, no, we are lucky, no one has come. No one appears for the petition on call. Good sir. Mr. S.R. Baru appears for
For response number 2 and 7.
2 and 7. He submits that he needs some more time to produce the record. Accordingly, list this matter after vacation or when? Or after, when this, next week or a week after that?
After vacation.
This is a matter after vacation. Mr.
I'm
S.R.
for-
Barua shall produce the records on the same day. Give a
For
date,
response
give a
number
date. Wait.
Response
Okay,
number
no.
4, sorry. Response number 4.
Okay, for S.R. Barua for respondent.
Supplementary admission at 40.
Great velocity, madam. Here there is a tender, madam, NIT. First NIT was issued, madam, on 3/8.
Just a
I have
minute.
called
Huh?
for, I have that requisition for that a copy of this affidavit, or in this matter only.
Okay, the affidavit is on the way.
Yes, yes, yes.
Okay.
Record is also our fault. That's why I said.
No, so basically the issue is that you were not selected, correct?
All out of 4 tenderers, all 3 were rejected. Solely on the ground of, so to say, car area development, car area certificate.
Not having
The
char area
earlier
certificate.
tender, madam, there is no that clause. In the earlier tender issued on 3/8/2024, that clause is not there. Their tender was without reason, giving reason was cancelled, and my second tender was issued on 3/9/2024. In that only this clause was injected, this area development. It is not mandatory also. It is, madam,
Let us
Right.
let us see, where is the clause?
first is also to come to the implicit manner. Here, manner, my tender was rejected on the ground. There is 4 grounds. Which-
No, let us see the clause on which
Yes, yes.
your tender was rejected.
Government has filed affidavit, my lord. Yes, we are paying for response number 5. We have not received a copy of the affidavit.
What to do, Mr. Arpit?
Which
Government affidavit. Yesterday they filed the,
he used to for this one.
yesterday they filed the affidavit.
You don't, why didn't you serve the respondent number 5?
I'll, then,
Huh?
then I'll start.
That too, we know you'll serve. The question is not that. The question is, why didn't you serve prior to filing it?
It will be taken up, my lord, the affidavit has to come to record also, my lord.
No, we have called for it. I thought everyone had it. That I can read it for 10 minutes. That's not the issue.
Let it be taken up on 12th, my lord.
No. We've got too many matters. We've got too many matters.
12th, then 17,
Otherwise,
otherwise,
there is some urgency in the minimum, minor.
Everyone's case, all your cases are urgent in this
No,
bench.
it is only
That's the
6 months, tender, madam, 6
You
months.
see, right now also we have
On
fixed
the-
so many partnered matters.
31st of March, madam, it is going to expire.
Huh?
6 months later, not 1 year even. That's why it is urgently fixed today, madam.
Okay, right. Mr. S.R. Barwa submits that affidavit has been filed on behalf of the respondent number
3 and 4.
3 and 4. Mr. Have you got it, Mr. Sharma?
Yeah, I have got. I will serve.
Mr. J. Roy, appearing for the point number 5. Submit that he has not received a copy of the affidavit filed by the respondents number 3 and 4. The same be provided by Mr. S.R. Barwa during the course of the day. Then what else to be done? You are not filing any reply.
Why fail?
Are you filing or
Huh?
are you filing a reply affidavit to the affidavit filed with them?
That reply to the private responsibility we file, my lord, that will cover.
Huh?
That will cover.
He filed it yesterday. Are you filing or not filing? It's a simple thing. You're not answering the question. Are you
Yes,
going to
we-
file? You'll file. How much time do you need?
But tomorrow, day after tomorrow,
You'll file the reply affidavit by tomorrow? Huh?
yes. Put up in the file it tomorrow,
Are you sure you'll file it by
Yes.
tomorrow?
you can file.
Okay. So that means tomorrow is Friday. What about you?
And we receive the copy then, my lord.
Okay, Mr. R.P. Sharma submit that he will file a reply affidavit to the affidavit filed by the respondents number 3 and 4 by tomorrow. This is a matter on 16.
Okay, can you be 12, my lord?
Huh?
12.
12, no, we have got a lot of matters. I'd love to do all your cases, unfortunately, we are very limited. Unless there was,
Anyway, your lordship is going very fast, my lord. Your lordship will be- you
Not
will
at all,
finish
not
the
at all.
next one any day.
what is there in your affidavit, Mr. Barwa? What is there in your affidavit? What is your case?
Lordship,
It has come just now. Anyway. Item,
My lord, I'm sorry, my lord, item number 3, my lord, I have missed, my lord, I was in court number 3, my lord.
we have 10 January.
Only my lord, none. That may.
Then what will be the reason for adjournment? What will be the reason for adjournment? Your prayer.
No, my lord, I'm praying for adjournment, my lord, only for non-APS may be given, my lord.
Item number?
Take 3, my lord.
Okay, right. Mr. What's
Yes,
your
Rana.
name? Huh?
Yes, Rana.
S. Rana. Appears for the petitioner. And seeks adjournment. Huh? Then you're right. And everything is safe.
I did 4 years. But the Lordship directed us to face the record, but we are trying our best to find it out. We could not trace out the record till now. But you may kindly grant us one opportunity last.
Look, Mr. Counsel, we have since September, we have been asked to get it. Now, you are trying your best to not do any more. Either you take a stand that you have it or you don't have it. Yeah, 2 months have gone by, more than 2 months have gone by. You have not faced it up.
But if the
This
record
will not
pertains,
do, huh?
and record pertains to 1996, 97, so that's why it is taking some time, Lordship.
My lord,
Yes.
my lord, this is, my lord, the second round of litigation, my lord. Earlier, there was a repetition in 2004, that is 3306 of 2004, that has been disposed of in 2006. But that is a reported case, my lord. My lord, if I may pray, my lord, that record may be placed on record, sir. That may be of some help, my lord.
In that case, Lordship can take it from.
No, that is disposed of already. Record may be called for of that repetition.
Why? How will that help you?
My lord, that repetition was the original repetition where we were directed to pay, my lord. Subsequent to
Correct,
these
correct. I
developments
know.
were there.
I know.
Yes, my lord.
Then,
Subsequent these developments, interdepartmental communications do.
Correct.
And as it was not done, my lord, we have filed the second repetition.
you see, Mr. Counsel, is the records of your contract there in the earlier writ petition? If it is there, why don't you produce it? You are the writ petitioner. This is your writ petition, second writ petition. If it is there, why didn't you bring it here?
No, no, my lord.
Then,
That record is not available with us now presently.
Mr. Counsel, you can always ask for examining the old records and bring out the documents there. Did you put any documents in the earlier writ petition? You did not put. That is why the court had directed that a verification should be conducted by the state respondents on the basis of their record, not on the basis of any records, because you did not have any records. Why waste time on
I'll try and that also in the meantime, if possible. I'll personally try that record if I should get.
that information? This should be ISO. ISO. It's also ISO, but I don't know where. Huh? You can know from this IFC code.
Check the IFC code on the name.
They will have it, the bank knows it. They have not given it to this person or now. Yes. Okay, right. Mr. R. Bora, learn counsel for the APDSL is granted further time to obtain the records. Inasmuch as the is granted one, no, last time already provided.
Yes.
Then we are calling the assistant general manager, right? Mr. R. Bora, learned counsel for the APDCL.
Actually, may I humbly pray, Worship may kindly direct the APDCL to verify the claim of the petitioner and in the meantime.
No, that was already done in 2004. This is the second round.
The managing director.
You're not.
Lordship.
No, let the officers come. We don't want to call. But this is the second writ petition filed by them. This is not done.
Just one more.
No. One more chance enough.
Actually, may be kindly.
No. Next time if this assistant general manager doesn't come, I'm going to call his boss. Be very clear about that. Assistant manager, let him come. Assistant general manager, let him come with the record. If he doesn't come, you can tell him, I'm going to call his boss also. Okay. Mr. R. Bora, learned counsel for the APDCL, prays for one last chance to produce the records. Full stop. On perusing the earlier order dated 12/11/2024 passed by this court, it is seen that the APDCL had been granted one last chance to produce the records, failing which the assistant general manager, TIOC electrical division was to produce the records. Next para. In view of the above order, in view of the last order dated 12/11/2024, and as the APDCL council has not produced the records, the assistant general manager, TIOC electrical division, is directed to personally appear before this court. On when? After vacation. On 7th. Along with the records pertaining to the claim made by the petitioner. The counsel for the APDCL is also directed to inform the respondents that as the order passed on 7/2/2007 has not been complied with. Passed in WPC 3306/2004 has not been complied with. Further consequences. There may be further consequences if the assistant general manager, TIOC electrical division, does not produce the records on the next day.
Lordship, may I pray your lordship may kindly grant us liberty in the meantime, that if we can find out, trace out the record, we'll verify his claim and release the payment, whatever is entitled to, lordship. That liberty may be granted to appeals, lordship.
Yeah, okay, it is in, okay, right. In the event that the records are produced, are, in the event that the records are found and the petitioner's claim is decided by the respondents during the interregnum period, comma, the personal appearance of the assistant general manager, so is, will be dispensed with.
Lordship. Much appreciated.
List the matter also.
Verify.
Yes,
Lordship, in this matter, Lordship wanted to examine the physical verification report of 29th of January.
so the issue was that the electrical meter was burnt.
And during verification, it was found that the burned meter contained external wires and circuits inside it, Your Lordship.
Some foreign object. was
Foreign
inside.
objects, Your Lordship.
Was inside.
But meter was sealed.
But meter was sealed, but there was a slight loosening of the hinge or something
Hinge,
like that.
the hinge, that was there. So the appellate
Hinge, my lord,
authority,
that is the appellate authority, my lord, found, meaning that with the hinge, my lord, I can open the meter. My lord, your lordships will see that hinge, my lord, how it can be opened, and if once it is open, my lord, that cannot be fixed again.
I don't know, they can open Godrej cupboards also. No,
My lord, no,
you see, I lost my Godrej
no, opening,
Almira keys.
my lord,
They opened not only my cupboard without the keys, and then the safe also. And then we took out the spare key from the safe.
no,
Then they hammered it here and there. It's usable, but but of course it's
No,
not
no.
very smooth anymore.
no, my.
But can be done. That's what
My
I'm saying.
submission is this, my lord, suppose this is a hinge, my lord.
Hmm.
The door is closed. That side is open, my lord, that hinge cannot be fixed it again. My lord.
Maybe, I don't know. Maybe. Let's see the report.
And earlier reports are very much there, my lord.
Lordship, one thing I found out, there was an examination of the burnt meter when it was decided that it will be sent for forensic analysis.
So,
On that day, seals were put on the meter for sending for forensic analysis in the presence of the consumer's representative. That report he had signed. And those very seals, Your Lordship, this report indicates that it was the same seals and seals were opened in this report. The seal numbers are there. Your Lordship. So it was sealed it was completely under seal during this period from the examination to this physical verification. It's flagged that or orange flag.
the burnt meat, the remains of foreign external wires is found inside the meter above the PCB. Foreign circuits are found inside the burnt meter, which is clearly visible. Foreign circuits, it implies clear case of interference. The burnt meter, which is displayed clearly, is packed in the original. There's a video also. Last page, last line.
Yes, there must be some video. Your Lordship.
There's a video. You have not brought the video.
This record does not contain the videos.
What about his submission that if it is closed, the door to the meter, whatever if it's closed, then how do you open the hinges?
Your
I don't
Lordship,
know.
what the appellate authority has concluded is, Your Lordship, the seal on one side is seal and one side there is a hinge.
Hinge, yeah.
The seal is intact. That is it.
yeah.
The seal is intact.
But the
But
hinge,
still the hinge could be removed because the metering, the foreign circuits were found inside the meter and that nobody has doubted, Your Lord. So there must be some way, Your Lordship, that the foreign circuits found their way inside the meter. The seals are intact, Your Lordship.
can I see the meter?
Uh,
You see, because sometimes the hinges are on the outside.
yes,
In the box, the hinges are outside. You know,
Yes.
it's a connecting thing.
yes, sir.
So whether it can be tampered with, we can know. Otherwise, if the hinges are inside, if it's closed and it's inside the thing, then how will it be opened?
Yes, that is the.
Yes, perhaps. What I have understood.
No,
from-
what I'm saying is because supposing the two views are possible.
Yes, Your Lordship.
Supposing two views are possible, taking the help of the criminal law, then the view in favor of this consumer, could it be taken?
Your Lordship, since this is not these are only assessment proceedings.
No, but then this will amount to theft of electricity.
Here only the assessment, if this is.
No, I think outright theft is also involved.
Yes.
So if,
That you have started the proceedings and I think 135 or something.
under 135.
135 is theft.
135. is
Then-
there. My submission, Your Lordship, would be the standard of proof required in these proceedings, where only the charges are to be assessed for unauthorized use of electricity, would be different from those in a criminal proceeding. There it has to be beyond reasonable doubt. But here, Your Lordship, the purpose of these proceedings are to ensure that the loss which has been caused to the distribution authority, that is recompensed.
No, the only reason I'm saying this because you are using the word theft.
Theft, Your Lordship, the word theft, when we use the proceedings under section 126, theft is also an act of unauthorized use of electricity. The only difference is that the element of dishonest intention comes, for which is also prosecuted under 135, for which there are separate punishments, Your Lordship. The proceedings under 126, Your Lordship, though it's theft, the purpose of these proceedings are to recompense the distribution authority for the electricity charges. Here, Your Lordship, if two views are possible, if two views are indeed possible, as Your Lordship has correctly put, perhaps by the ratio laid down in Suryadev Rai, unless the view of the appellate authority or the inferior tribunal court is completely impossible from the materials placed before it, Your Lordship.
That is there also.
Yes, that is perhaps the position, Your Lordship. Because after going through the materials in place before it, Your Lordship, it has come to a conclusion that yes, the hinges could have been opened. This inspection report, Your Lordship, curiously, it was never put to challenge by him also. This verification report.
You see, this report does not speak of hinges.
This report does not speak of
Then-
hinges. This report, Your Lordship, because it does not, why it does not speak of hinges is because it is only supposed to look at what happened to the meter, Your Lordship.
No, but it has not even made a mention of the hinges. There are things inside, no doubt.
Yes, Your Lordship. That, Your Lordship, because
Because now the
there is one more thing, Your Lordship. The meter, the hinges are not in the meter, Your Lordship. It is in the cabinet box.
in the cabinet.
Because I just
Okay,
rechecked.
the hinges are in the cabinet.
Yes, what the appellate authority says is the appellant indulged in malpractice. A foreign circuit was found in the meter, which proved the malpractice within the premises of the appellant. The seal of the cabinet box was found intact, but it does not imply that the meter cabinet box cannot be opened for tampering the meter, as one side of the cabinet box cover is hinged, giving ample opportunity to open the door.
Can you give me the videograph? You bring the videograph, that'll be clear.
I'll get. Lordship, have it on Monday or I'll.
Okay, right. Mr. KP Pathak, Learned Counsel for the APDCL, shall produce the videograph of the physical verification of the meter undertaken on 29/1/2016 on the next date. This is the matter on when? 16? No. 17. Okay.
Well,
you-
can
you-
it be on 19 balance?
No.
18th. 18th. 18th.
I think there's. Will there be motions, many motions, I wonder that.
And it will be the last week before the vacation, so it will perhaps.
Well, let me say 17, it may be like, it may be.
We'll try on 18th, if it's not possible, we'll adjourn it.
Very well.
Anyway, this matters of 2017, a few days here and there won't make a difference. 18th.
Very well. Lordship, may I take the record, may I take back the record?
Yes, he'll back.
Item 6 and 7.
And if you can bring the meter also.
I'll try and get a.
Yeah, just,
Or
therefore,
pick
yes,
off that meter.
just to have an idea.
Very well.
Actually, you had fixed it today, but there were so many other matters fixed already prior to this. Anyway. No?
Item number six, sir.
Huh?
Item number 6. First item.
Where is Mr. Das Gupta? Is he coming? Yes, huh? Okay, so what to do? Where is the? What is to be done? Are we, is it going to be done or not done or what? This hearing?
I have come. Reason item. Juniors also are not seen. Venu application, Venu question. I think.
What is to be done? I don't know. He's on. Who? Yeah, he's coming. Mr. Das Gupta.
He's coming.
Okay.
He will.
Okay, then you can just recapitulate a little bit, just a little bit, just to, so that your submissions also have a flow. Yeah. Well, basically, Milord, we will have threefold submission, Milord. First is, Milord, the conciliation settlement which took place and which are annexes 1 and 2. Conciliation settlements, there were 3 of them, I think. Yeah, yes, 3. In all, it is 3 with the latest one. Yes. At that moment, Milord, it was 2, 1 and 2. One is 11, 8, 10, and the other is 28, 5, 13. So what about the third settlement? That came during the pendency, which is part of. So it doesn't have any significance or any relevance or what? No, because that is after this expiry of these settlements, the new settlement was again a conciliation settlement. That was done in 22, and it's an annexure to our additional affidavit. I will place that. But that also will not. No, so the 2 settlements. Yeah. Now, what was the main issue? The pay parity given. No. These settlements, my lord, are periodical settlements. Okay. The earlier settlements expired, then this first settlement. And this 2010, and its period of tenure is 1/1/10 to 31/12/19. And the second conciliation settlement was dated 28/5/13, and period is 1/7/12 to 36/22. First, related to one class of work, labor, contract labor, they are called listed 1. And the second settlement, annexure 2, related to two categories, namely listed 2 and 3. Okay, first settlement for listed 1. Yes, listed 1. And second settlement was for listed 2. Listed 2 and 3. Finally, when the 22 settlement came, it has become 1. Okay. Because at that point of time, there was a earlier settlement. That's why dates were not going. They were divided by the year 2000, I think. Yes. Listed 1 was listed 1 was prior to 2000. Listed 2 after 2000. What about listed 3? Listed 3 is they are that is not applicable to them so far as 2 and 3 is one agreement. 2 and 3 the second settlement. Second settlement. So they are both post 2000. 2000 is that listed 1 and first settlement. So now the issue is, despite the settlement, yes, the pay parity had been done by the concerned officer. Oh. Yes. The settlement, my lord, our first submission will be, my lord, these conciliation settlements are, my lord, cover all workers. All workers, all aspects of that category, because whether your union was a party or not, that is the effect of Section 18. Therefore, and there was a clause in this agreement that you will not raise any dispute during the currency of the tenure. So we when the demand came, this time, and it was before the deputy CLC, we, in writing, told him by letter that the settlements are in operation. Therefore, you don't go into these matters and demands at this moment. Because then you will, then they will always raise the truth, and then it again a settlement comes in. But during the currency of the settlement, with a clause saying that you will not raise any demand, our submission will be that this should have been taken up by the respondent.
But then the clause only said, I think, that if it is not taken up, I mean, if they take up an issue despite the settlement, then they will not be bound by the settlement. Isn't it?
Your lordship is right. That clause said that it will be withdrawn.
So once it is withdrawn,
Ah.
then the settlement doesn't apply to them. Then
That is all right, my lord, but that has an impact on others.
maybe,
Ah.
maybe.
No.
But you are basically allowing for a person to opt out from the settlement
Yes.
by putting in that clause.
No, my lord.
Let us see the clause.
Yes. Page. First one, page 34. Page 34.
32,
34.
34.
First. 34.
Page 34 is affidavit.
Yes.
As a clause of the settlement.
Yes.
8150.
Huh?
WC 8150.
Oh, okay.
8150 of 17.
Oh.
Clause 8, page 30.
Clause 8.
Yes. It has been agreed by the unions as well as the beneficiary listed WCLs that the above settlement is in full and final settlement of all their demands. Neither the unions nor any individual listed WCL who will be availing benefits of this settlement will raise any demand, dispute whatsoever on any matter, any of the matter settled therein, and on any issue raised in the charter of demand, including the matter of regularization during the tenure of this settlement. In the event of raising of any demand or dispute on any of the said issues by the unions, individual listed WCL, the settlement would stand cancelled, and the benefits under the settlement would stand withdrawn in respect of the concerned listed WCL members of the concerned union. This is your lordship was referring. The terms of the settlement will be effective from the tenure 1110 to 31/12/19. So this is the clause. This clause, my lord, covers not only the members of the unions, because this union, several unions participated, I think, no? Because they are signed by two unions.
No, I'm not on that.
Right.
It covers everyone.
Yes.
No doubt about that. The issue is that supposing someone brings out a demand which has already been settled, then in that case, the settlement clauses will not be applicable to that person any further.
My lord, the bar comes, my lord, in the form that so long the settlement remains, you are not required or you are not permitted to raise a dispute on these matters.
But then you see,
No.
you see,
Suppose, this has been also dealt with. I'll place
Okay.
that dealt with. Because you can't allow a splinter group
to raise issues, to frustrate and disturb the.
So show me, just clarify this point first.
Yes, I'll place these judgments which will indicate.
No, because you see, that is inhibiting
Ah.
my further thought.
Yes,
You see, unless the questions that I have at the different stages of your argument are answered as and when we reach that stage,
Oh.
then it becomes, a long list of questions, and then that sequence is lost.
I'll go by your lordship.
Yes, so that that,
I-
so that we
I'll
can
cite-
understand.
That's why I was thinking I'll cite the cases so
Yes.
that your lordships can have the legal framework. And then your lordships can also appreciate this.
Correct,
clause.
correct. So now the basic.
May I start with the,
Yes, no, just to recapitulate. So the basic thing,
Right.
I think Mr. Das Gupta is all ears also for that.
he was not here, but good thing.
So the basic thing is that there was this settlement made. The first settlement was made for this list. And
The
the
second case-
2013, again, second settlement was made for the
to close.
listed 2 and 3. Now during that time, some persons have again raised the issue of getting pay parity again with the employees, the permanent employees of the ONGC. Correct?
That's right, Miller.
Now, and that DCLC or something,
This year, deputy
chief legal something,
respondent number.
that DCLC,
Ah.
he has, by interviewing
Hmm.
some of the
group,
employees,
both-
group of employees,
Hmm.
basically group 1 employees or something like that,
13 in one group
ah,
and 14 in
Yes.
other group.
has
Contract
come,
and regular.
has said that the pay should be as per this. Their pay should be made applicable to these persons who are on contract.
No, they are already taking benefits of this settlement.
Ah,
So what he was doing is they first raised a dispute and then it was under the industrial dispute side. But they changed it to a demand under Rule 25 of Contract Labor and Regulation Act, which provides that if you have this same and similar job and doing it, then the terms and conditions of the regular employee will apply to you.
okay.
And
So,
that question is permitted to be considered by the Deputy Chief Labor Commissioner.
okay. Now what is wrong with that?
There is nothing wrong, except if you have a settlement in operation.
Then, okay. Then you
And
cannot do it
It
during
is
that. time.
binding on all employees, which is the effect of section 18. Then to raise a dispute before the period ends
Hence,
impacts the atmosphere and the terms of that settlement.
so basically, they cannot raise an issue during the validity of the settlement.
That will be my,
That is your case.
that will be my first submission.
Okay, that's it. So there cannot be
Conciliatory settlement being binding on all workers. The demand made by the respondent union is not permissible under the law. That will.
So the thing is, there cannot be a dispute / demand raised
Yes,
during the validity of the conciliatory settlement. That is your number one
yeah.
issue. Then what is your second point?
The second point will be, my lord, that in the scheme of things under the Contract Labor Act, the contractor is the immediate employer. And the principal employer is the
ONGC,
Oil India.
Oil India.
If you start the proceeding, assuming that is legal, and you are starting that proceeding under Rule 25, then how do you proceed is very important, because this relates to a very important issue having a lot of implications in the industry of this type, because there will be a lot of contractors and a lot of contractual employees working under various departments. Therefore, whether contractor should have been made a party or at least summoned, because under the Act and the rules, the lordships will find that the contractor also is required to maintain his records and is responsible for that. And therefore, our submission is that if you start the proceeding, then you ought to hear the contractor, number one. Secondly, you are going to change, suppose you uphold their demands, you are going to give the same terms and conditions as the regular employees. Would you not give a notice to the employer, main principal employer? Why is he having a system of regular employees and contractual employees? Is he not entitled to place his case? How do you proceed? You come here, stay there for 3 days, go to the and visit the 8 departments out of 36 departments, and you pass an order. Is that the procedure of wage fixing or determining whether the terms and conditions are similar and same? This is virtually wage fixation. And if your lordship see his main finding, he comes to the finding that it is not identical. If it is not identical, you cannot determine the wages the way you have done.
So your case is that there cannot be a dispute demand raised during the validity of the conciliatory proceeding. Number 2 is that the contractor should have been made a party.
At least he should be summoned. Made a party means that you must have a procedure to go about so that there is a fair amount of information from both sides. Then only you can say that they are same or similar. If you don't hear the contractor, if you don't give notice to the main employer, why are they doing this? There must be a reason.
So notice was not given to you.
No, because the procedure itself is very curious.
He went and he took evidence on his
He
own.
stays there for 3 days and visits 8 out of 36 departments, and he takes the statements of these 13 and 14, which are not given to us, but our representatives were present when the statements were made, and then he passes an order. It's a bizarre way of fixing wages. And he comes to a finding that it is not identical. And yet he says, he takes the basic of the regular and adds his own amounts. some 8,000, some 5,000, some 3,000 and all that. Hmm? Because without the scheme of the Act, Contract Labor and Regulation Evolution Act, because I placed the relevant rules. Give me that act. Because basically, this act recognizes the contractor as the immediate employer and the principal employer, that means the person who is having the registration,
All India,
All India, as
as the principal employer.
principal employer. So, and the rules indicate the records, how it will be maintained, who will maintain and all that. If your lordships kindly see, so for wages is concerned at page 35, if your lordship is having that bare act of universal. Rule 63. So it starts, the contractor shall fix the wage periods in respect of which wages shall be payable, most wages.
No, page 63,
Page, rule 63, my lord, page 30,
contract, page
page
30,
35,
page 35,
yes.
rule 63, yes.
This is relating to wages and the contractor has certain things to do that is set out.
The contractor shall fix wages periods in respect of which.
Yeah. That is that he's responsible to fix and also pay. And then kindly turn over the page. Come to the registers and records and collection of statistics. Rule 74 onwards. Register of persons employed. Every contractor shall maintain in respect of each registered establishment where he employs contract labor, a register in Form A specified in the schedule to the ease of compliance to maintain registers under various labor rules under 2017. So that is the register he is required to. And 76, every contractor shall issue an employment card.
Okay, basically now you are, where is that, the impugned order?
Yes.
That, where is that impugned order?
Page 60, my lord.
Page 60.
Yes.
Now, page 60 is the impugned order. This has been made on some case number or something, or just an order, just simpliciter.
No,
How did this order come about?
order, he goes there, he goes.
No, there was a dispute raised
Yes,
by the,
correct.
there was a conciliatory proceeding that did not fructify. So then I guess there was a reference made.
No.
How did it?
So
how
far,
did it?
this demand is concerned, there was no conciliation proceeding. They approached the officer concerned, respondent number 2.
They approached R2. Who's R2?
R2 is the person who has passed this order.
The DCLC.
Deputy Chief Labor Commissioner, Central.
So they approached the Deputy Chief Labor Commissioner and he did it. That's all.
Yeah. And he first asked his junior to go about it. He could not
give a report.
So,
If we have not.
so
received.
it did.
And then he comes to the Duliajan for 3 days and he visits these 8 departments and then he takes
So,
this
so the
step.
first question is whether this DCLC can can straight away go into the issue under this contract labor regulation. He can,
He is the authority.
under section,
Rule 25.
under rule 25.
He is the authority.
Now, the contract labor rule.
1971.
He can go into the,
Yes, sir.
he can go into the issue straight away. Now, your grievance is basically, he has not followed any procedure.
Yes.
That procedure is not a procedure for fixation of minimum wages.
So what should be the procedure?
Procedure, this is ultimately this is a question relating to fixation of wages
Correct,
of the contractual employees.
correct.
Because Rule 25 says that if they are doing the same and similar work, they will get this. Therefore, you have to go into that question. What is similar, same, whether they are working, what is the nature of their employment, what is the mode of their employment, what is the work they are doing. All these relevant aspects he has to consider. How do you consider? If you don't hear the employer, if you don't hear the contractor, and you just go and visit and then you take statements from 13 and 14 from these 2 groups and pass an order. And at page 75, your lordship finds, he comes to the conclusion that they are not identical. If they are not identical, you have no business to go further into the matter of parity. Because I'll place those judgments. The Supreme Court has said.
Let us see the operative portion of this order.
Yes, kindly see that.
Page 75.
Page 75 is his finding.
Let us see the finding.
Yes. It starts at page 60, Miller. Page 75.
After perusal of the above statement.
Yes. After perusal of the above statements of contract workers
There is no total similarity.
and permanent employees, it is a fact that there is no total similarity in the job context of both types of workmen. But it has also been established that there is similarity in job contents of these workmen to a great extent with a few exceptions. You can't be more vague than this.
Vague or ambiguous?
Ambiguous, and his finding is that it's not identical. The contract was categorized as so and so, so and so, so and so, are working since long and have acquired sufficient skill and knowledge of their work. They have worked in other shops and sections also, so they are having varied experience. They have proved their utility by helping the management in core activities of the company whenever engaged. The permanent employees may have different nomenclature so far as their designation is concerned, but they are performing also almost same type of job as that of contract workers. The duty hours of contract workers are same in comparison to permanent employees. It was also observed during the inquiry that permanent employees, although supervising the work of contract workers in some cases, are also doing the same work as a team, and there is no differentiation in the nature of the work of these workmen. The
No,
inquiry
but then you see, this is also ambiguous. When you say supervising, so he's a supervisor. Supervisor is slightly different.
That's the problem with this.
No.
That's the
I'm
problem.
just telling you this just to keep, I'll ask you questions on this later.
May I say something?
Yes,
Yes,
yes.
So far, Rule 25 is concerned,
Ah.
very much clear.
Ah.
Whether the contract worker is performing same or similar nature of jobs.
Okay, same or similar?
Similar nature of. If it is not same, then whether he is similar nature of job. That is the content.
No, but then what do you mean by similar? Similar at 5% similarity, 10% similarity,
I don't.
50%, how much?
That is
What is
different.
that percentage of similarity?
That is major portion.
So is
similar.
that
Major portion.
is-
And
but it-
their case,
Huh.
if your lordship goes through their pleadings or the documents, it is not their case that we are not performing same and similar jobs.
Okay.
Their case is that you are bounded by the settlement. So you cannot raise any dispute. First point. Second point is that you cannot claim equal pay for equal wages if your source of recruitment are different, status is different, so you cannot claim. These are the two basic points.
Two basic points according to you is number
Their
one.
cases.
Their case is according to you.
There is a binding settlement. And during the continuance of the of this settlement, you cannot raise any other dispute which have an effect on wages. Because according to them, your wage has been settled by the conciliatory settlement. And there is a clause that you cannot raise any demand. Despite this clause, how you can demand this? So that is their case.
And number two is?
Number two is
Let me.
No, just, I just wanted to know. Number two is?
Number two is that the equal pay for equal wages has to be considered with some other references, whether your status, which source
Equal
of
pay for equal work.
according to them,
Equal pay for equal work.
that as for equal pay for equal wage, when you are to asserting equal pay for equal wages, you have to see some other factors, the status of the workers, source of recruitment, etc. What they are saying that our principal employees are recruited through a recruitment
Different
process.
recruitment process.
Through a recruitment process. They are to should have some eligible educational qualification.
Okay.
And you don't have this. So you cannot claim. This is the 2 points what I have understood is their contention.
Okay. Yes, Mr. Goswami, I think I have got a little bit more information. Yes. What is the next point?
No, you don't.
Yes, please, carry on.
That's what I think. It was also observed during the inquiry that permanent employees, although supervising the work of contract workers in some cases, are also doing the same work as a team, and there is no differentiation in the nature of job of the workmen. The inquiry was conducted on random sampling basis. It has also come to the notice of the authority that there are many field stations of the company where contract laborers are not performing the same job as being done by the permanent employees, so there cannot be any comparison in respect of job contexts of both types of workmen engaged in this station. So if this is your finding, the question is, can you say, now let us proceed a little more and then see. As such, this is its conclusion. As such, justice demands that the contract workers in the category of WCL listed one performing the job of cleaner and helper in subsections like production, oil production, so and so field and all that, and figuring in the list of the union should be given rupees 27,629 towards wages plus 5,000 on account of one-time fixation of benefit per month. So far, as contract workers in the category of WCL2 performing the job of cleaner and helper, there are three categories involved, Millard. One was this cleaner and helper, and then I think the medical, and third is security. stop it, claim, they should be given to 27,629 towards wages plus 3,000. So 5,000 to one group, 3,000 to one group as one-time fixation benefit per month. The contract workers in the category of WCL listed 3 engaged as cleaner and helper in the shop stations whose name figure in the list of unions should be given 27,629 towards wages per month. This category he has not added the additional amount because he has added below, they are getting 16,000 and odd, which I'll show at another page. And he is now raising it by 10,000 and making it 27,629. Well, it's a, I have not seen wage fixation in this manner. But what is more important to you, if you record these findings, that they are not identical, that their job content is also not same, then can you come to a finding that they are doing the same work as the regular and therefore pay parity should be there? It is not on a basis of experience and long period of service that Rule 25 enables him to fix the wages. He has to see the content of the both regular and contractual worker and then come to a conclusion that it is one and the same and absolutely identical. Then Rule 25 gives him the power that all the wages and other benefits given to the regular will be given to them. You don't have to fix a wage the way you are doing. If you come to that particular conclusion of parity and same and similar nature of work, then the conclusion is already there in the rule, in Rule 25. Kindly have a look at Rule 25 now. What is the nature of the power in 25? Kindly have a look. May I place the entire rule first? Because it's better to refresh. Forms and terms and conditions of license. Every license granted under subsection 1 of section 12 shall be generated electronically in form so and so, annexed to the rationalization of forms and all that. Every license granted under sub-rule 1 or renewed under Rule 29 shall be subject to the following conditions, namely, the license shall be non-transferable. The number of workmen employed as contract labor in the establishment shall not on any day exceed the maximum number specified in the license, save as provided in these rules. The fees paid for the grant or as the case may be for renewal of the license shall be non-refundable. The rates of wages payable to the workmen by the contractor shall not be less than the rates prescribed under Minimum Wages Act 1948 for such employment where applicable, and where the rates have been fixed by agreement, settlement, or award, or by the appropriate government, not less than the rates so fixed. So this is the relevant clause 4, Roman 4. First, it should not be less than the Minimum Wages Act. We'll show your lordship the notification under that. It is, our payment is far exceeding not only the Minimum Wages Act, but even it is better than the other PSUs of central government member. The rates of wages payable to the workman by the contractor shall not be less than the rates prescribed in minimum wages, and where the rates have been fixed by agreement, settlement, or award, not less than the rates so fixed. So, if you have a settlement, then you have to go by the settlement. Otherwise, the minimum.
No, it does not say that.
Yes, no.
It says that where the rates have been fixed by agreement, settlement, or what,
Yeah, where the applicable and where the rates have been fixed by agreement, settlement or award, or by the appropriate government,
Not less than the rate so fixed.
not less than the rates so
So
fixed.
fixed.
So
So,
first without the minimum wages act, and if you have settlement, award, or the governmental direction, not less than those. In our case, it will be the settlement. Then comes, my lord, this clause 5A.
rule, just let us go to 12, section 12.1, okay?
Yes.
Section 12.1
Yes.
License probably.
is the license.
Licensing of contract. With effect from such date as the appropriate government may by notification in the official gazette appoint no contractor to whom this act applies shall undertake or execute any work through contract labor except under and in accordance with the license issued in that behalf by the licensing officer. Subject to the provisions of this act, a license under subsection 1 may contain such conditions, including in particular conditions as to hour of work, fixation of wages, and other essential amenities in respect of contract labor as the appropriate government may deem fit to impose in accordance with the rules, if any, made under section 35 and shall be issued on payment of such fees and on the deposit of such sum, if any, as security for due performance. This is the provision, my lord, for a. Now, my lord, if your lordships now go to Roman 5 of Rule 25, this is what we are concerned with. In cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wage rates of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. So this is the provision which says that if they are performing same or similar kind of work as the workman directly employed by the principal employer, then what will be the effect or result? That is also prescribed. The wage rates of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same and similar kind of work. Therefore, he is not required. He is required to only find out whether they are doing the same or similar work. If he comes to a finding that yes, they are doing the same and similar work, the consequence of that finding is already inbuilt in 5A. Namely, that then they will get whatever the regular employee is getting.
5A.
Roman 5A, below.
Yes.
That is inbuilt.
So it will be done by the same person, the DCLC.
Yes. Now, if he finds that it is same, then the consequence is mentioned.
Correct.
Then the wages of this and conditions of this regular worker will be theirs. There is no dispute on that. But if you don't find that, your finding is not that. You are saying at page 75 that they are not identical and the nature of their function is different, content of functions. If you come to that finding, then your jurisdiction ends with that finding. You can't then go back and say, oh, yes, but they have worked for long periods.
Okay.
Their experience.
Got it,
Therefore,
got it.
not
got it.
for experience and long period, this rule is prescribed. It is prescribed only on one condition, namely that you have to come to a conclusion that there is the identity of the nature of the functions. of both the groups. If that is there, then the consequences spelled out in the rule itself. You are not there to fix below 5,000, 10,000, 8,000. What will happen is, if your lordship just kindly have a look at page 58. He's giving this figure, 27,629. If your lordships kindly turn to the page of 58, this is where it comes, it's a pay scale of attendant grade 1, that is the lowest group of the regular employee. And he says this, 27,629. Your lordship has seen at page 75 and 76 that he says that add one-time benefit of 5,000, 3,000, and therefore, then we turn over the page and turn to page 59. This is the contractual forecast pay scale at that time. That was sometime in 17. This is listed 1, listed 2, and listed 3. These are contractual employees.
Yes.
They were getting, at that point of time, the listed 1 was getting 26,597.96. But he is making it 27,629. That means he is adding about 1,032 to 26,597 and making it 27,629, which your lordship has seen at page 58 as the regular employees work. Your lordship remember 75, he is talking about
Yes.
27,629. 27,629 is the total wages of that regular employee at that particular time. And of the contractual employee at page 59, listed 1 was drawing 26,597.96. First, he makes it 27,629 by adding 1,032 and then add that 5,000, 3,000 and all that. And the third listed 3, if you see the last entry at that page 59,
Yes.
they are getting 16,998.58.
Yes.
Now, he is giving him 27,629. That means he is adding 10,000 rupees more to bring him to this 27,629. Therefore, he is not giving anything more. He is adding 10,000 to him and to bring him to that level. So it's a very, if I can understand that you come to a finding under Rule 25(4) that yes, these people are doing the same thing and similar thing. Then you need not fix the wages. You say that all wages, therefore, of the regular employees will be available to them.
Same.
And that's about all. You are not required to give, add and then do that. They will be entitled to the salary of a regular person as your lordship has seen at page 50 and 59. So first of all, he is finding that it is not identical, job content different. That will not by itself takes it away from 25(4), Roman 4. So the subsequent edition
Yes.
to make it 27,629 and then add another 5,000 as one-time benefit or something he's calling. That is absolutely not authorized under the law. He is not a wage fixer. He has to find out whether they are same or not. If he says that they are same, consequences spelled out in the rule itself, namely the same wages of the regular employee will be available to them. He can't, distribute like that 5,000, 6,000, whatever he likes, he is giving. But that is not how wages are fixed, and that is not contemplated under the rule. It only says that you find out whether it is same and similar. If it is so, then the wages of the regular employee will be available to you. Where is the question of adding something or Oh, everything, only 17 of them. It is absolutely not. Page 80.
Anything else?
Yes. So, my lord, he comes, kindly see now at page 80.
Yes.
He is now giving virtually a contradictory finding. In view of the above, contract workers categorized as 1P and 3 of Oil India Limited mentioned in the application of the union and in respect of whom an inquiry has been conducted by the authority under Rule 25(2)(5)(a) of contract rules have been found to be performing the same and similar kind of work as of a regular employee of the company for pretty long time. Hence, their monthly wages should commensurate with their volume of work, hours of work, weekly off, and other conditions of service with a view to bring about parity in comparison to regular employees to the possible extent. As such, the wages of these contract laborers, known as WCL 1, 2, 3, is fixed in the following manner. So, category is security guard, 1, 2, and 3. And then, my lord, wages fixed on monthly basis, 27,629, 5,000 is equal to 32,629. Similarly, next page, medical attendant, and third, my lord, medical attendant 3, all these 1, 2, 3. So they are giving 27,500, 3,000, and cleaner and helper also 5,000. And however, if the above WCL contract laborers are entitled for more wages and other benefits like leave, bonus, annual increment due to existing settlements, any award or court order, they will get the same. These contract laborers will also not be barred from getting more wages and other benefits like leave, bonus, annual increment as a result of future settlement, award, or court. So that is, first of all, he finds that they are not identical, job content not same. And then he says that they have worked for long, therefore they have acquired experience, therefore they are doing the same work. And then he gives the wages, fixes the wages the way he has done, which your lordship has seen at page 76 and page 80. That's the sum and substance of what he has done. Now, if your lordships kindly turn to the writ petition, starting at para 17, page 18. The petitioner begs to state that the mere reading of the impugned order will show that respondent number 2 was totally biased against the petitioner, and apparently he has converted the first application of the union to an application under Rule 25 of rules. It is not understood as to how respondent number 2 can compare an unskilled workman's job with that of a job of a junior engineer, which is a highly qualified technical person. The respondent number 2 was fully aware that oil has its permanent workmen from grade 1 to 9, and unskilled regular employees who enters into grade 1 of regular skills required around 25 years to enter into grade 9. After appearing in the written examination, vivacy for promotion to the next higher grade, provided the vacancy arises in the next higher grade. Highly technically qualified persons who have passed and obtain apprentice certificate under the Apprentice Act or a degree from IITI with technical qualifications are only recruited to grade 5 after written, oral, and trade test. Accordingly, an unskilled contract laborers cannot be equated with a skilled workman, as has been done by the respondent number 2 while passing the impugned order. In this regard, the petitioner begs to state that a regular employee who enters into grade 1 after going through a written and vivacy gets total monthly salary of 27,806 in comparison to the monthly salary of listed WSL, who doesn't come through any such selection process and gets a total monthly salary of 26,597 in respect of listed 1, whereas listed 2 and 3 gets monthly 25,565 TLP, respectively on 3970. Then, my lord, security guard. Because your lordships will see why we are saying this, because from his own order, your lordships will see this is the regular 13 employees he has whose statements he took, and page 64 and 65, if your lordships have a look. So this is the contract laborers at page 64. And page 65 is the regular. But see, Willard, the grades are given there in that column, first, second, third. Paramedical technician, grade 8.
Where are you reading?
Page 65.
Yeah.
He says the details of 13 regular employees working in the same shops whose statements have been recorded are given here as under. So he is taking, for example, this person, paramedical technician, a person from grade 8, and then comparing with the contractual employees. Then next is the security guard. Security guard grade 5.
Who will be grade 1?
Grade 1 is the first entry point.
Nah, who will that be?
Grade one, he has not even bothered to see.
No, but for my knowledge,
Yes,
what is grade, who will be grade one?
grade one will be. No, who are they normally?
Initial entry.
That much I know.
Every department
No,
should.
that much I know, but
Ah.
who, what job are they doing? What is their job profile?
There are different.
Are
jobs.
they gardeners? Are they cooks?
No,
Are they
not-
chowkidars?
No,
What are they?
not gardeners, but there will be different types
No,
of
sir,
work.
let us know. You
Eh,
see, because what is,
For
what is,
example,
what
Vinod,
is grade one? What
the
is grade two?
Kindly see page 65 itself, regular. This is the list of 13 regular.
No, that's all right.
He is
You
a
see,
technician.
because the lowest he has seen out here is grade 4 or grade EG3. Now what is, now EG3?
No,
Yes.
this is below. First you start at grade one, then
Correct,
you start getting promotion.
correct.
Ah.
That's why I want to
Therefore,
know who is grade one? Is it a chowkidar? Is it, what is it?
No, this fellow who has joined All
Ah.
India for the first time,
Who
is now shown at grade 5,
yes.
he was grade 1.
So what is the
Over-
post? What is the grade one
Same
post?
this technician.
Acha, they are
paramedical
same post.
Yeah,
Same post, so
Yeah.
they come from grade 1 to grade 2. Okay,
Ah.
okay.
from
Same.
grade 1 to grade 9.
Okay, okay.
you know.
So if a chowkidar is grade 1,
Ah.
he'll become chowkidar grade 2, grade 3, grade 4, grade 8. Okay.
But normally, these 3 categories are only involved. So for this case is concerned,
Yes.
the medical security and helper. These are the 3 categories. Now coming back, to page 19. We have, from para 17 onwards, we have shown how and he has compared with which regular employee of which grade. If your lordship sees page 118 now, page 19, paragraph 18.
Yes.
Petitioner begs to state that the impugn order that is trying to bring on the equal pay for equal work by comparing the work of regular employees of the company working in grade 5 to 9 with that of the contract laborers who are performing unskilled work. A regular security guard after getting promotion from grade 1 to 5 will necessarily earn more than any other regular security guard of
This
grade
is all
1.
right. These are the normal.
And these are not disputed also.
What
in
is
the-
that to read?
Yeah. And then,
Unless you are going to
next
show
we
me
are
some.
dealing with at page 20, medical attendant.
Page 20.
Yes.
Okay, then.
Then we are page, paragraph 19 is medical attendant. And paragraph 20 is cleaner and helper. For example, see the medical attendant, Begs to state similarly, while dealing with the case of medical attendant, compared a contract labor with paramedical technician of grade 8, which itself amounts to comparing a highly skilled person with an unskilled workman. Admittedly, a paramedical technician of grade A is highly skilled employee recruited directly as per company's recruitment process who can provide all medical assistance in emergency to a patient even in the absence of a doctor. However, contract labor who is working in a medical department taking patient to the CT scan and X-ray room and doing bed maintenance cannot be held to be performing same and similar kind of work like that of a paramedical technician, nor it can be held he is performing equal work like paramedical technician to get equal pay. Failure to consider those vital aspects of the matter itself shows that the respondent number 2 by Kukakur tried to give benefits to conflict laborers to extra some page. Para 20 again below, just see for cleaner and helper. Compare the number of cleaner and helper with that of junior assistant 1 of production oil in grade 5, operator of operation in grade 8, assistant operator grade 5 of production gas, junior engineer 2 of grade 9 in the field communication, mechanic 2 and grade 5 8 of electrical engineering with that of contract laborers. The respondent number 2 was fully aware that those regular employees of grade 5 to 9 were all skilled employees having either their electrical license or diploma in telecommunications and or diploma certificate under the Apprentice Act. Accordingly, the respondent number 2 would not have compared highly skilled technical employees recruited directly as per necessary recruitment guidelines with the unskilled contract laborers. It is a settled law that equal pay must depend on the nature of the work done. It cannot be judged by mere volume of work. There may be qualitative difference as regards reliability and responsibility. It is also settled law that different pay scales having regard to different educational qualifications can also be made, and it will not amount to violation of equal pay. Accordingly, comparison of cleaner helper also without any basis and all that. So these are all undisputed. They have filed an affidavit, they have not disputed this. Why I am saying that, as I was alluding, if you have a process, known process of waste fixation, if you had taken the evidence of these people, contractual workers, regular workers, employers, and if you need the contractor, that would have given him the basic situation as to whether he can compare one with the other. He has not done anything of the kind. He is going around the 8 department, calls some 13 and 14 from one group and 14 from the other group, and take their statements, Milord. And without these differences, that is a matter absolutely unknown to waste fixation in Milord. Therefore, these are all, if he had taken this could have been the evidence from the side of the employer. Then what you cannot do this.
Just 5 minutes.
Yes, please. The problem has been because of that, Milord. What I was saying that there must be a known process you should have adopted. Waste fixation, Supreme Court has said that it is a matter not for court. You need to have some experts to. Lord, may I just show one page to indicate the present state of wages? Yes. Just to have a glimpse of that, Milord. That your lordships will get at page. Affidavit con ascending. That affidavit starting at page 121. Additional affidavit, Milord. At page 129.
Page 129.
It starts from 121 at page 129.
Yes.
Waste structure of listed WCL as on 1/1/22. If your lordship sees, listed 1 is getting 39,943.32.
Yes.
And 2 and 3 also the same.
Yes.
Now, if your lordships kindly turn to page 132. One 132, waste structure of listed WCS with effect from 1/1/23.
Yes.
This is below 46,254.76. If you have signed the MOU,
But which MOU?
that, 136,
136 MOU is of,
the new one, the latest.
okay.
But
No, but then,
no,
okay,
I'm just giving your lordships an idea of the wage,
correct.
because ultimately, it comes down to that. How much do you take home at the end of the month?
No, that is that, but this is in terms of the 22 wage settlement.
Yes.
Now, but
Because it
they are probably asking for back wages from.
No, I am not on that, back wages thing. I am only indicating, what is the state, because I showed you our lordship at page, whatever that page up to 2017. At present, it has gone up, and the regular group, is getting 40,900, 994.
So they're getting less.
40,000, that is his total, And there was a further rise, which makes it 41,541 as on 1/1.
Where do you get that?
No, this is my instruction. This was as of 2012-22. But if your lordships won on 1st January 23, the amount will be 41,541 instead of 40,994.
Anyway, that is.
No, I am only indicating the present state of amount they are
How does
getting.
how does make it?
So it is 131 and then 132,
129 and 132.
129 and 132. If your lordship sees, it is for 132 is for WCL, workers. 123. Those who signed the settlement are getting 46,254. If they have not signed, then it is 39,943 at page 129. That's the difference.
Yes.
And that's why your lordship was dealing with that application of 100 people who resign.
Yeah.
This is the difference which has prompted them to do it. If they sign that undertaking as required under the settlement, they will get 46,254. But without that, they are getting what your lordship has seen at page 129, 1339 or something. $129 is 39,943. Otherwise, it will be 46,250. That's the present scenario. So it's not that we are coming for the first time here. We have also informed the respondent number 2 by our letters, which are at page 50 and 54. Our grounds that why you should not enter into this matter at this stage. That was there, and what how it is different and why it is different, those things were mentioned there. Only thing, if we had taken a little trouble to have a proper proceeding, which is the requirement for fixation of a waste, then both sides should have given thing, and they would have reduced evidence also that this is the situation, this is our case, and employer and the contractor would have given the contrary thing. Then he could have come to a finding. Otherwise, these findings which are challenged, your lordship has seen the primary requirement of an identity in the jobs that is missing. Without that, you can't have parity. I'll place these judgments now. Complete identity is required. And as far as minimum wages is concerned, it is far less. Because
So we're not on that.
no, under the rule also, minimum wages, if there is nothing else. But if you have a settlement, if you have an award, or if you have a Government of India's order, then that will be the thing. And here, my lord, we have April 23 minimum wages notification. That is very less, my lord. For unskilled, it is 494 per day, and for 26 days only, 12,844. And highly skilled is my lord 816, and his salary would have been 21,216 if it is counted as 26 days. Otherwise, it was 24,480. So if you compare the minimum wages to the settlement wages.
Why are we going into that issue?
No, I'm giving an indication, my lord, that it is not as if, you know, they are exploited. In a state.
It is not their case that they exploited. It is
No.
their case that they want something more. That's all.
No, something more, yes, you know, if they are satisfied.
They're not satisfied. They are greedy. That's why.
No, I'm not saying greedy, but.
That's what they are implying.
Who doesn't want a little more?
That is what. So it's a natural tendency to want more. Everybody wants
I
more.
wouldn't say greedy.
Unless you're a saint or you're a,
That's
some
right,
going to
absolutely
the
right.
Himalayas to meditate.
Absolutely right.
So no.
That's the.
Look in the context of the people here.
And if you see
Yeah,
the context.
your fees now and your fees 20 years ago will be different.
Obviously, we know. So are the.
So will the salary of the judges
So are
and
the
everyone.
wages of the learned judges.
Everyone.
So
there's nothing out of the ordinary that they're asking.
No, I'm not saying.
Only thing is whether
Only thing I am saying.
justified or not the order. That's all.
That is all right, but their demand, of course, Miller, who is not going to make a demand? They have to.
Correct.
There's no problem about that. But if you ask for equality or parity, the law has evolved.
Okay.
There you have
So let's stick to that.
You can't be, it is not Farman.
Otherwise, we are going to take forever in the submissions. After you, he has got to submit.
Yes.
And so I think let us start with the citations.
So minimum wages I have dealt with. This is one. This 5 is gone. Now I move to the judgments.
Oh my God. Huge. Quite thick.
We have, in one page, we have given this.
You should have maybe bound this thing, otherwise it'll go here, there, everywhere.
I see. Okay, we'll do it, Philip.
Spiral binding can be done. Very cheap, spiral binding.
300 rupees.
300.
No problem. Get it done. We'll get it done.
Yeah. With the. It's okay, they've already done this. How does it matter?
No, we'll take it and give it to a lot of letter. So first thing first, what is the effect of a settlement under section 18? That is important.
Okay.
So the first case is 98-1 SCC 650. I have given the paragraphs also, which are relevant. And then the 3 cases we are giving. I'll just take your lordship to that first case, 98-1 SCC 650, paragraph 7, 8. Para 7, the section 18 is set out,
Yes.
There are two types, one is an agreement signed between the parties, the other is a settlement in conciliation. And the impact of both are different. At para 8, page 658,
Yes.
the aforesaid relevant provision therefore leave no room for doubt that once a written settlement is arrived at during the conciliation proceeding, such settlement under section 12(3) has a binding effect not only on the signatory to the settlement, but also on all parties to the industrial dispute, which would cover the entire body of workmen, not only existing workmen, but also future workmen. Such a settlement during conciliation proceeding has the legal effect as an award of labor court, tribunal, national tribunal, or an arbitration award. They all stand on par. It is easy to visualize that settlement contemplated by section 12(3) necessary means of a written settlement which could be based on written agreement where signatories to settlement sign the agreement. Therefore, settlement under section 12(3) during conciliation proceedings and all other settlements contemplated by section 2(p) outside conciliation must be based on written agreements. Written agreements would become settlements contemplated by section 2(p), read with section 12(3) of the Act when arrived at during conciliation proceedings or even outside conciliation proceedings. Thus, written agreements would become settlements after relevant procedure for provisions for arriving at such settlements are followed. Yet, thus all settlements necessarily are based on written agreements between the parties. It is impossible to accept the submission of the learned counsel for the appearance that settlements between the parties are different from agreements between the parties. It is right to observe that all settlement must be based on written agreements, and such written agreements get embedded in settlements. But all agreements may not necessarily be settlement till the aforesaid procedure giving them the status of such settlement is followed. In other words, under the scheme of the Act, all settlements are necessarily to be treated as binding agreements between the parties, but all agreements may not be settlements so as to have binding effect as provided under section 18(1) or 3. If necessary procedure for giving such status is not followed in a given case. On the aforesaid scheme, on the aforesaid scheme of the Act, therefore, it must be held that the settlement arrived at during conciliation proceedings between so and so on the one hand and 4 or 5 unions of the other has a binding effect under section 18(3) of the Act, not only on the members of the signatory unions, but also on the remaining workmen who were represented by the 5th union, which, though having taken part in conciliation, refused to sign the settlement. It is axiomatic that if such settlement arrived during conciliation is binding on even future workmen as laid down in section 18(3), it would ipso facto bind all existing workmen who are all parties to the industrial dispute and who may not be members of unions that are signatory to such settlement under section 12(3). And then below at paragraph 11, if you look it.
So basically, everyone
Everyone.
who's
That's difference between-
working for the oil India.
Even
Whether-
future,
Whether he's a part of the union who had signed it or not.
it doesn't matter. 18(3), even people who will be employed in future,
Yes, yes.
it will be binding. Now kindly turn for one more page below 661, paragraph 11. This is set out the thing very clearly. In Barauni Refinery versus so-and-so, Ahmedi J, as he then was speaking for a bench of 2 learned judges of this court, had an occasion to consider the binding effect of such a settlement arrived during conciliation proceedings in the light of section 18 of the Act. The following pertinent observation in this connection were made. A settlement arrived at in the course of conciliation proceedings with a recognized majority union will be binding on all workmen of the establishment, even those who belong to the minority union which had objected to the same. To that extent, it departs from the ordinary law of contract. The object obviously is to uphold the sanctity of settlement reached with the active assistance of the conciliation officer and to discourage an individual employee or a minority union from scuttling the settlement. There is an underlying assumption that a settlement reached with the help of conciliation officer must be fair and reasonable and can therefore safely be made binding not only on the workmen belonging to the union signing the settlement, but also on others. That is why a settlement arrived at in the course of conciliation proceedings is put on a par with an award made by the adjudicatory authority.
So this has expanded the inclusion of even those persons who belong to a minority opinion who has objected to the settlement.
Correct.
So it basically, it's quite wide.
Quite right.
So it covers you also,
Yes.
basically.
Yes.
These judgments.
Yes, sir.
Yes.
So this is one, then we have given.
Anyway, in this case, who were the
lordship-
persons who had raised the dispute? Were they a part of the union who had signed the settlement?
Yes, yes.
They were part.
Yes.
Oh, you all were part of the union that
Yeah,
signed the
yes.
settlement.
That is
This settlement, even these
Yes.
employees are beneficiaries. We have said that is not denied.
Oh.
They have taken benefit. Otherwise, they will not get this kind of a wage, Milord. One more case, Milord.
Yeah.
This is important for a reason, Milord. 2000, volume 1, FCC 371, para 24 and 25.
Yeah.
At page 393. It talks about the splinter group. That's important, Miller. Miller, paragraph 24 is at page 390.
Yes, I've got it. I've got it.
You've got it, Miller. And towards the end, Miller, I'm not reading the whole thing. About 6-7 lines from the bottom.
Yes,
A
yes.
settlement which is sought to be included has to be scanned and scrutinized. Subsection 1 and 3 of the section 18 divide settlements into two categories, namely those arrived at outside the conciliation proceedings and those arrived in course of conciliation proceedings. A settlement which belongs to the first category has a limited application in that it merely binds the parties to the agreement. But the settlement belonging to the second category has an extended application since it is binding on all the parties to the industrial dispute, to all others who were summoned to appear in the conciliation proceedings, and to all persons employed in the establishment or part of the establishment, as the case may be, to which the dispute related on the date of the dispute, and to all others who joined the establishment there.
Yes, yes.
That is mentioned in 18 itself. A settlement arrived at in course of conciliation proceedings with a recognized majority union will be binding on all workmen of the establishment, even those who belong to the minority union which had objected to the same. We recognize the union.
I don't think you've got to read anymore.
That's right.
No, we have admitted this thing.
Only one line from the paragraph 25, Miller. In a last sentence of paragraph 25,
Yes.
in all these negotiations based on collective bargaining, the individual workman necessarily recedes to the background. Settlements will encompass all the disputes existing at the time of the settlement, except those specifically left out. There can be many splinter groups. This is what I was talking. Each forming a separate trade union. Under section 4 of the Trade Unions Act, any 7 or more members of a trade union can get the trade union registered under that act. If every trade union having a few members is to go on raising a dispute, and the state government making reference again and again, the very purpose of settlement is defeated. Once there is a representative union, which in the present case is the labor union, it's difficult to see the role of the workers' union. So that it goes to the other thing, but this splinter group shouldn't scuttle that.
But this is not the case here.
No, I'm only indicating the width of the.
Yes, the width of the settlement, the ambit, yes.
So the others are also there, but I am not troubling your lordship. Like 2002 dictionary, if I'm looking. 2002, volume 3, SCC 411, your lordship may note.
You've got this 2005 also you have mentioned, 2005 3 SCC 49.
No, it's all right, because
That's not required.
same thing is repeated. And 2002 3 SCC 4411. There your lordship can note below paragraph 15, 19 and 21. Yes, no? Oh. That has been given. That also will have some relevance.
So this 2005 8 is not necessary.
2000.
No. Yeah, you see one thing. You have given me your index 2005 3.
Yes.
And what you have
It
given
is
me
relevant.
2005 8. You have given me state of Uttaranchal
Oh, yes.
versus Jaspal Singh Tyagi. This is
No.
2005 8.
Yes,
It
it
is
is
not
only for
three.
one thing, my lord. Para 4, your lordship can note down. Para 4.
Yes.
If you take benefits as these workers have taken, para 4, my lord, at page 50.
Yes.
Last sentence, having obtained the benefit, it was not open to him to turn down without justifiable reasons to contend that the settlement was not fair.
Okay.
That's only for that.
Okay. He's covering all aspects.
Yes, section 30 is irrelevant of Contract Labour Regulation Abolition Act.
Okay. We'll see.
That's a non-obstinate clause.
Huh?
Section 30 of the Contract Labour Regulation Abolition Act there is a non-obstinate clause.
Okay, let us see. Anyway, let us see this.
So let him
Yes, 2002 3 SCC 411. You have referred to page para 15. That is ITC Limited Workers Welfare Association.
No, he is mentioning, which one you are mentioning?
This 2002 3 SCC.
Section 30.
Oh, yeah, going straight to section 30. Okay, yes, let us see. Let us see section 30.
This is the normal provision, Miller. Effect of laws and agreements inconsistent with this act. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law or in terms of any agreement or contract of service or in any standing orders applicable to the establishment whether made before or after the commencement of this act. Provided that where under any such agreement, contract of service or standing orders, the contract labor employed in the establishment are entitled to benefit in respect of any matter which are more favorable to them than those to which they would be entitled under this act, the contract labor shall continue to be entitled to the more favorable benefits in respect of the matter, notwithstanding that they receive benefit in respect of other matters under this act. So this is the overall provision to override any other law which may be inconsistent with this provisions. But this law doesn't, operate. If your lordships kindly make a little note, 98-1 SCC 650. First judgment which I didn't cite.
Yes.
It is already noted, 98-1 SCC 650.
Yes.
That dealt with a similar provision under the Industrial Disputes Act.
Yes.
35Z.
And what did it say?
And it says, Miller, that 98, para 13. Para 13 at page 662, Miller. effect of laws inconsistent with this chapter, section 25J, which is set out. The provisions of this act shall have an effect notwithstanding anything inconsistent therewith contained in any other law, including standing orders and all that. These are all in almost most of these acts, conferring rights to the laborers. This clause remains because
So, but then there's, so his argument also makes sense. If he's getting a better deal,
that is also provided.
That-
itself,
then
then he will get it.
he'll get it.
Ah.
Only thing is, of course, now we go back to so that issue with regard to the finality of a settlement is not there.
Not
Ah.
disputed.
Finality of settlement is not there. If he's entitled to a better deal as per law, he can get it.
And the learned respondent number 2 also has last paragraph, he has kept that provision. That if you are getting more under any other settlement or law, you will still get it. That he has kept.
Where, who has kept?
The impute order.
Okay.
That
So
is
now,
always there.
so now the only issue basically is with regard to whether the manner in which he has come to his final decision
Absolutely.
Yes,
is based.
Absolutely.
is-
Your
is-
lordship is
is-
absolutely right.
decision-making process.
Yes, that's all.
The decision-making process, my lord,
That is the only thing.
with all respect, my lord, I am saying, it's something very bizarre. You can't have a waste fixation in this process. That you go, make an inspection visually, take statements, and it's not given to anyone for cross-examination or anything. There has to be an orderly proceeding, my lord, known to law. Otherwise, my lord, such a issue of waste fixation and considering the nature of the industry, where, my lord, is a huge number of contract laborers, it will be have huge implications as a result of this.
Okay, no, that implications, so we cannot go into.
No, I am saying that is the reason why.
That is the reason why you have come to.
You need to give opportunity and know the
Correct.
views. Why they are being put like this? Instead of making them regular. There may be reasons which the employer could have told him if an opportunity was given. As
So-
we have said
so
in our letters.
So your judgments on settlement goes because of section 30. Now let us go to the next batch of
19,
citation.
on this mirror 98-1 SCC 650, which is there at serial 1, your lordship may just note para 13, so far as section 30 is concerned. Para 13.
Yes. Para 13.
Yes.
Yes.
It deals with 25J of the Industrial Disputes Act. Effect of laws inconsistent with this chapter.
Yes.
And next page is paragraph 14, 14 at 663. It is difficult to appreciate how the said proviso can be of any assistance to the appellant. So all that is stated is that anything inconsistent with the provisions of chapter 5A found to have been laid down by any other law, including standard, will have no effect. Even subsection 2 of subsection 25 is to the same effect. Therefore, section 25 overrides any inconsistent provision of any other law or otherwise binding rule of conduct and makes the provision of chapter 5A operative of their own. Para 14. And then paragraph 15, they quote from another judgment of the Supreme Court. The submission of the learned counsel for the appellant in the connection of the effect that any other law is provided in 25J1 would include even industrial dispute act, especially provision contained in section 18. There it is difficult to agree. The section nowhere provides that the provisions of chapter 8.
I think we can go to the next stage. I think this stage, so we have We have basically decided the issue.
So this first is gone. Then contractor not a party.
Ah,
I'll give two decisions.
yes,
90 volume 1 SCC 68.
yes.
Food Corporation, paragraph 6, 7, 8, 9. Six, your lordship sees.
Yes,
It is no doubt true in the middle, it is no doubt true that the employer and contractors are both liable to maintain registers in respect of workers employed. But the corporation seems to have some problems in collating the list of all workers engaged in the depots scattered at different places. It has requested the commissioner to summon the contractors to produce the respective list of workers engaged by them. The commissioner did not summon the contractors nor the list maintained by them. He has stated that the corporation has failed to produce the evidence. Question is, in our opinion, is not whether one has failed to produce evidence. The question is whether the commissioner, who is the statutory authority, has exercised powers vested in him to collect the relevant evidence before determining the amount payable under the Act. It is of importance to remember that the commissioner, while conducting an inquiry under Section 7A, has the same powers as that of the Code of Civil Procedure for trying a suit that is mentioned below. And then paragraph 19, it will be seen from the above provisions of the commissioner is authorized to enforce attendance of a person and also to examine any person on oath. He has the power of requiring discovery and protection of documents. This power was given to the commissioner to decide abstract questions of law, but only to determine actual concrete differences in payment of contribution and other dues by identifying the evidence and collate the all materials before coming to proper conclusion. That is the legal duty of the commissioner. It would be failure to exercise the jurisdiction, particularly when a party to the proceeding requests for summoning evidence from a particular person. We therefore allow the appeal, reverse the order of the commissioner and that of the High Court. The matter stands remitted to the commissioner to dispose it of afresh in accordance with law in the light of the observations made. Here also, if your lordships have a look at Rule 75 at page 36. Rule 75, Miller. Every contractor shall maintain in respect of each register whether the employee's contract labor is registered in form A specified in so and so. Employment card. Then below 78, master roll, wage register, deduction register, and overtime register. All these are required to be maintained by the contractor. Shall, in respect of each work on which they engage as contract labor, maintain master roll, register of wages, and all this is there, Milord. Every contractor shall have wait period and all that. And then Milord 80. Rule 80. All registers and other records required to be maintained under the Act and the rules shall be maintained and complete and up to date, and unless otherwise provided for, shall be kept at an office, sir, or nearest convenient building within the precincts of the workplace or at a place within the radius of 3 kilometers. Such registers shall be maintained legibly in English and Hindi or in language understood by the majority of the person employed in the establishment. All the registers and other records shall be preserved in original for a period of 3 calendar years from the day of last entry. All registers, records, and notices maintained under the Act or rules shall be produced on demand before the inspector or any other authority under the Act or any person authorized in their behalf by the central law. So this is the power below, which is obligation, and he has all registers, records, notices maintained.
No, but then.
Shall be produced.
No, but what is the relevance of this? You see, the settlement has already provided what they will be getting. And prima facie, it will be better than the pay given in the register.
Correct.
Now, so the only thing now is whether the pay that was given by the DCLC is better than the settlement. That is clear better than the settlement. Now, once that is clear, the only thing that has to be seen is whether the procedure, a proper procedure was followed or not, if there is a procedure. Now, this register apparently it doesn't help anyone. How does it help
No, what
you or him or any other
What
person?
I'm saying is, this power, all the registers, record notices maintained under the act and it shall be produced on demand before the inspector or any other.
If there is a demand, if there's no demand, then there's no requirement.
No, but what I am saying is that we approach the commissioner, respondent to call the contractor because he was the person, immediate employer. He engages these contract laborers and he is in the know of things about the work they do, nature of the work they do, the qualifications if possible. So this is a power which is given. We page 50 and 54, we specifically told the respondent number 2 that this is available, you kindly call the contractor also. It is just to indicate, my lord, that is possible under this rule 84.
To prove what?
Prove, my lord, that his my lord, nature of his work and all.
Nature of his work, you are the employer. Where
No,
is
no.
You are the principal employer.
My lord, that
You are actually using his services.
no, true, but you see, my lord, he is the person who is.
He is only keeping a register. The
No,
actual
he is
work
the-
is being done under you.
No, my lord, he is the immediate employer and disciplinary action is given, the power is.
No, that is that, but
Therefore-
it depends upon the context in which the register is required.
Well, if I just, you let your lordship come back. I just show our page 51 and
Page 50
51, I think.
51 of the 51 of the writ petition.
Yes.
Or what? Huh? 51 of the writ petition.
This was addressed to the applicant. It is clear from the above license control. Contractor is liable to.
51 of the writ petition.
Yes, page 51.
Yes, what about 51?
It is clear from the above license condition that the contractor is liable to extend all the benefits as stipulated in the provision in case of performing same and similar kind of work by the contract laborers with the workmen directly engaged by the principal employer. Therefore, the concerned contractor is under obligation to comply with the said license condition, and in case of any disagreement with regard to type of work, the CLC is empowered to decide the same. Hence, without making the contractor as a party to this proceeding, the dispute cannot be settled. That is our contention, and we wanted him to summon him also, not only for the records, but also he would be the best person because he is engaging them and bringing. Getting
The
it done.
actual work is being done by them inside your premises.
Yes,
The
I mean,
contractor is nowhere in your
that is,
premises.
that is the whole purpose of
The only thing the contractor will be having is maybe in his register working as maybe as a sweeper, but inside your premises be working as something else.
No, you will have to go by the whatever is. written
You'll have
there.
to go by whatever has been being done in your premises.
No, the contractors is the immediate employer.
Maybe.
And suppose.
No, it is the immediate
No.
employee in the manner that it provides the manpower. That's all.
No,
Not
not
an-
only that. He is also the disciplinary authority. for-
Okay, and also pays the so which
Well,
has been
that
paid
is
by
a
you.
statutory obligation, he has to pay.
Anyway, we'll see. up to-
If he doesn't pay, then the principal employer is made liable.
Let us carry on at 2.
Before your lordship's right, item number 8, my lord, my friend appears for the petitioner, my lord. Sabi petitioner.
Right.
Can it be some other, actually, I'm in the midst of a matter.
No problem.
After vacation,
Okay, right. On the prayer of the parties, list the matter after the vacation.
interim order will continue till.
Interim order to continue till the next day.
Better?
Yes.
That may be,
9, yes.
yes. Because it will not otherwise reach, because it may be after vacation.
Okay. You tell that? Okay. Let's see.
Yeah. But I was on this second middle contractor, not a party. Koragon, Food Corporation, I think we have done. This is Bharat.
Yes, you are on the 2008 CSCC.
This was under Employees State Insurance Act 1948, which also related to computation of the contribution. In that context, the question arose whether the contractor should be summoned. And paragraph 28 and 30, my lord. In 28, it is referring to a judgment. The respondent is also directed to impede the contractors, subcontractors, if it feels that they are necessary and proper parties on the basis of information furnished by the petitioner for adjudication of the matter in controversy and to proceed further. Then paragraph 30, it appears that the determining authority did not give an opportunity of hearing to the petitioner in regard to the names and other particulars of the contractor. The impugned judgment therefore cannot be sustained. It is set aside accordingly. The appeal is allowed that the matter is remitted to the ASI Corporation for determining authority for considering the matter afresh. The authority shall either implead the contractors as parties and or summon them for producing necessary record for the said purpose. In the facts and circumstances, there will be no order. So that is in the paragraph 24, it refers to the provisions of the Contract Labor Act also.
Which paragraph are you relying upon?
28 and 30, but 24 also deals, refers to the Contract Labor Regulation Act. The contractor is required to maintain register and all that. Yes. How you are pending? 2008, 3. It was 2008 dilu, no? Or 2001, 8 dilu. So contractor may be summoned as a party or as a person.
There's nothing that you have been able to show that requires that he must be summoned.
No, it's not a question of must be summoned, but we said that you better have the contractor also because he will have the record.
What is he going to say? What is the contractor going to say?
1352 they say they claim members. So there has to be some material to say.
No, you know who you are employing. You give
No,
your-
we do not know. That is the whole problem.
But how do you know who is working where?
No, Milord, your lordship will kindly see the situation is like this. Contractors are engaged after advertisement. They bring the employees. Assignments are made by the company and the contractors also.
You see, the number of persons who are working or not working, that is a side issue. The issue here is basically with regard to whether the pay parity was correctly given or not.
No, that is.
So let us not digress into
No,
something.
I quite follow that, Milord, but I was indicating, Milord, that the inquiry also.
That can always be done later after we decide this issue either this way or that way. If we find that okay, that the you don't have a case or you have a case, then we can say that let the contractors be given and
settlement pay or the new pay should be given only to only those persons who are in the register. That's a different issue.
That is all right. Well, I am not saying that it is a must, but I am indicating that if there is a request and there is a relevance, it is possible to summon the contractor.
Correct, that is there, that is.
That is all that I am. And,
Okay, so third ground.
yes. Because paragraph 24 of that judgment also refers particularly to contract labor. Now, then, my lord, equal pay for equal.
Yes, now this is the case, yes.
Thirty-nine and 40. 2019 7 SCC 658
2019, yes.
7 SCC 658 Steel Authority of India versus Wilson. It refers to paragraph 36 at page 7674, my lord. It is referring to the very same provisions. 25 is quoted.
Paragraph
Paragraph 36.
36, okay.
Para 39 and 40. To make it further clear, Rule 25. Para 39 and.
Yes, I've got it. How does this help?
39 refers to the Rule 25 and to be complied with by the and if at all there is any breach of the conditions, complaint can be made. That is all right. At the same time, an obligation, para 40, to provide the immunities conferred by the Act to the workers and the primary responsibilities of a contractor that each worker employed by him as contract labor has to be paid his dues before the expiry of such as may prescribe with an exception provided under section 21(4) of the Act in case the contractor fails to make payment of the wages within the period, and then the principal and employer shall be liable to the contract labor employed by the contractor and recover the amount from the contractor. Here, my lord, after the act, there was a division, and the question was whether the wages will be payable by the contractor or the employer. So
But that's not the issue here.
in that context, it was said.
So 2019 7 SCC is not relevant.
Not that way.
No, not relevant to the issue.
It is a contractor's it should have gone under contract payment. Now, equal pay for equal work, that is more crucial for us, pay parity. So, 2000. 2007 13 FCC 231. This is important, so far pay parity is concerned. Paragraph 6. The principle of equal pay for equal work has undergone a sea change. Earlier, the view of this court was that if two persons are discharging the same functions, they will be entitled to the same wages. Subsequently, this view has been changed, and now the view of this court is that there should be complete and total identity between the two persons similarly situated so as to grant equal pay for equal work. So this is what I am relying on. There should be complete and total identity between two persons similarly situated so as to grant equal pay for equal work. Recently, this court has held that identity between two persons has to be complete and total. In case of a regular appointee, he has undergone a selection process and his services are regular. Even if a daily wage employee is discharging the same function as a regular employee, the authorities are not bound to grant equal pay to such a person who is appointed on daily wage basis, that is appointed for a short term and has not faced the selection process. Thus, the principle of equal pay for equal work has to be granted only if there is a total and complete identity between the two persons. In this view, we are supported by a decision of this court in S.C. Chandra versus State of Jharkhand. That case is 2007, 8 SCC 279. One of us, in the aforesaid case, one of us, Katyuj, in his concurring judgment, has held that granting pay scale is an executive or legislative function and not a judicial function. There is a separation of power under the Constitution between the three organs, and the judiciary should not encroach into the domain of other organs. Montesquieu theory of separation of powers broadly applies to India. In view of the legal position as mentioned above, we are of the opinion that the view taken by the High Court granting pay scale of regular employees to daily wage employees does not appear to be well founded. Consequently, we allow these appeals and set aside the order of the High. So this complete and total identity, that has to be
But you have to elaborate. What do you mean by complete and total identity?
that is, that will be the yardstick to judge whether there is a commonness in the two sets of employees. Namely, the relevant guidelines will be the mode of recruitment. Suppose there is a test and a proper procedure, and people apply and then they select the test. So for regular, that is provided under their rules. So far as contract labor is concerned, the contractor engages them and puts up wherever the employer desires them to be there. So the mode of appointment is entirely different. One is a competitive selection process, and the other is without that. And then the question of responsibility is another angle where it has to be seen and come to a conclusion that the responsibility is safe. Similarly, educational qualifications may be one of the conditions. So these are the relevant parameters by which the commonness is determined. If commonness is missing, then you can't claim that you have to get the same pay as the regular. And that is why it is saying.
Okay, next.
And that is why it is saying that it must be complete identity, and that he is referring to that 2007 8 SCC 279. That's a judgment. My learned friend wants me to cite this case, 2017 1 SCC 148, State of Punjab and others versus Jagjit Singh. I am not troubling your lordship with this. It is a virtually a review of entire Supreme Court judgments on this, both sides cases are discussed.
Justice Kehar Singh.
Justice Kehar, is right. So ultimately what happens, suppose it is all same. What is the relief that was granted? Therefore, I go to the last page. Paragraph 61, page 224. So 61, Miller. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale at the lowest grade in the regular pay scale, extended to regular employees holding the same post. So the final relief is, my lord, after having found that they can be also treated with the same pay. What has been done is they are put at the bottom of the minimum of the scale of the regular.
In your case, is there a pay scale?
Yes, yes. So far as below regular employees are concerned, we have
Pay scale.
in 2010 itself, we have given that provision so far as the contract laborers are concerned in our establishment. They will be getting the minimum of the scale. Here, if your lordships want, that page is, I think, the first judgment, first agreement, no? 2010. We gave that, which was granted by Supreme Court in 2017 to get the minimum of this scale. And on that basis, in so many cases, all the high courts have been giving who are not regular or who are not there. That page 32 of our settlement, Miller, clause 1, wages.
Yes, page.
Page 32 of our petition, Miller, the first agreement. I just want to show the clause, Miller. This is 2010. No? This is the 2010 agreement, settlement. Wages, basic, A, 1A. The starting basic pay of grade 1 of the company's regular employees, presently 4,800 per month, will be paid to listed WCLs. As and when this basic pay is revised for the company's regular employees, the same revised starting basic pay of grade 1 will be made applicable to the listed WL with effect from 1/1/10. This is there in all the agreement. So it's we give the basic, and thereafter all the benefits which are being given, that is enumerated. Provident fund, gratuity, and all that, whatever is payable to them. Therefore, this which is been given by the Supreme Court at by this judgment in 2017 was given in our first settlement itself in 2010. So they get the basic of the grade. Then I think we have 89-2 SCC. SCC 235. No, there are 4, 5, and 8, 7 also. Paragraph 4, my lord, your lordship has got it, page 239.
They put on the ACs. Very well.
May I place it? May I place it? Para 4, 239. About the doctrine of equal pay for equal work is not expressly declared a fundamental right under the Constitution, but Article 339D, read with Article 2 declares Constitution goal enjoining the state not to deny any person equality before law in matters related to employment, including the scales of pay. Then it is said without the 1416 enjoins the state, and where all things are equal, persons holding identical posts performing identical and similar duties under the same employer should not be treated differently in the matter of their pay. The doctrine of equal pay for equal work is not abstract one. It is open to the state to prescribe different scales of pay for different posts having regard to educational qualification, duties, and responsibilities of the post. The principle of equal pay for equal work is applicable when employees holding the same rank perform similar functions and discharge similar duties and responsibilities are treated differently. It must be the same rank also. The application of the doctrine will arise where the employees are equal in every respect, but they are denied equality in matters relating to the scale of pay. Then the other cases which are there, they are referred to. In all these cases, court granted relief for the application of the doctrine of equal pay for equal work. While then they say that there can be classification and different kinds of.
You see, instead of reading all the judgments, that is, we're going to take a long
No,
time.
no, I'm not. Therefore,
Because they have got to also.
I don't want to read below. I'm only giving the
operative
operating and the relevant part. The para 7 deals with educational qualifications. If there is some difference below, that is a factor to be taken into. That is all. Then this principle of equality will not come. And para 8 also reaffirms that. Educational qualification has been recognized as a valid basis for qualification. So this is that. Okay. Then 98 1 SCC 422. There are 14, 15, 16, 17. I'm giving the paragraph, but I'll just read only one paragraph for you. Paragraph 15 at page 427. It is also a settled proposition that evaluations of such jobs for the purpose of pay scale must be left to an expert body, and unless there are any malafide, evaluation should be accepted. So equal pay for equal work is a fundamental right and all that. So that is. Year to 2009, 17 FCC 318. Good. This is what you may get from feedback on this.
Why are you giving so many things, same issues?
I don't want to, but
I mean, it's,
this is
this could have been explained in 2-3
yes.
judgments. You're giving so many. What is this?
I'm trying to minimize because there are so many more.
No,
Your
even
lordship,
I can,
it is
even I
good
can
to
add
your
another
lordship.
10 of them.
I quite see.
And then, it's
This case may be of some relevance because it also refers to this particular act, 2009 17 SCC 318. Para 11 at page 320. In para 10, they refer to that rule 25(2)(5)(a). 11, nature of work, duties and responsibilities attached thereto are relevant in comparing and evaluating as to whether the workman employed through contractor perform the same or similar kind of work as the workman directly employed by the principal employer. Degree of skill and various dimensions of a given job have to be gone into to reach a conclusion that the nature of duties of the staff in two categories are on a par or otherwise. Often the difference may be of a degree. It is well settled that nature of work cannot be judged by mere volume of work. There may be qualitative differences as regards reliability and responsibility. In the instant case, except recording that the contract labor engaged through contract is doing the similar work, the labor commissioner in his order has not adverted to the evidence and materials placed before him. At least there was some evidence and materials placed before him to judge that question. And then that is set out. And if your lordships, paragraph 14, middle, the labor commissioner ought to have adverted to the nature of duties of the staff in two categories, degree of skill, dimensions of the job for reaching the conclusion that the work done by the contract labor in the second filtration point is the same or similar to the kind of work done by the employees employed by the company. There is no discussion at all by the labor commissioner as to how he arrived at the conclusion about the similarity of work. The evidence let in by the parties and the materials placed by them seem to have not at all been considered by the labor commissioner. At least he wanted the materials from the parties, but the court finds that he has not given enough attention to that. And now thereafter, in paragraph 16, the conclusion. We are afraid the consideration of the question as to whether the workmen employed by the contractors in the second filtration plant perform the same or similar kind of work as the employees directly employed by the principal and employed in the main plant by the labor commissioner as well as the High Court is highly unsatisfactory. In a situation such as this, we are constrained to set aside the judgment of the High Court as well as the order dated so-and-so passed by the labor commissioner. The application made by the union under Rule 25(2)(5)(a) of the rules is restored to file of the labor commissioner, Kanpur, for fresh consideration in accordance with law. So there, at least the materials were there. It was not referred to. Therefore, court says that this is very unsatisfactory. Sets aside and sends it back. In our case, my lord, your lordship has seen the process. Ought to have been something of that kind, even for Rule 25. And if you don't do that and just go and find out some workers take their statements and then, and what do you record as a finding? That they are not identical. If they are not identical, there is an end of the matter. Page 75 is his findings. So this again, my lord, is the considerations which are necessary to be taken, that is mentioned. And if there is not there, they have paused and sent it back. Okay. Others, I have given the paragraph, I am not repeating the same thing over again. So therefore, my lord, my respectful submission is the procedure adopted is something which is not known to law. Even if it is a summary procedure, you should have adopted, got the adhesions of both the parties, and then decide the matter from the point of view which are mentioned in this, and then come to a conclusion. But if you have come to a conclusion that it is not identical, then for my purpose, that is good enough to attract these judgments and to set aside that order. I think I have covered the list. Yes. So I am deeply grateful for this. Huh?
Yes, it has to continue.
Huh?
We have to do this first. Item 7, we're doing item 7 now.
Next matter.
We're doing item 7 now. So item 7 will have to be, let the reply come.
Let it be over, then we will start this, no?
Then item 7, we continue with item, no, we're doing right now, we are doing 8150.
Deeply obliged.
That be the worship. Look, Contract Labor Regulation and Abolition Act was enacted in the year 1970. Basic object of this act was to abolish the contract labor system. If
Basic concept is to
abolish the contract labor system. If it is not possible, then it has to be regulated. Now, it has to be regulated. Now, one of the mode of regulation is Rule 25, 2, 5A and B. That is one of them regulated. This rule, I will not repeat, probably your lordship has gone through it. This rule specifically states that what will be the age of a contractor, contract laborer, etc., etc. Now, it also, so far 5A is concerned, it states that if it is found that the contract laborers are performing, one thing is very much clear, should be bear in mind, same or similar job. Not only same job, but or similar job, then their scale will be same and similar or identical to the principal employer. It is
It is same and similar or same or?
Same or similar, my lord.
Same or same.
That is, now,
Or similar.
same or similar. Now, so far this point is concerned, it has been argued that you are contract laborer, your mode of recruitment is defined, then that of the principal employer. And your qualification is defined, then that of the principal employer. So the principles of equal pay and equal weight is not applicable. This is the sum and substance of the argument put forward by my mind learned speaker.
That is one.
I will answer. That is one. Second question is that whether the contractor's presence in the proceeding is required or not. To appreciate the job contents of the principal employees of the principal employer and of the employees of the contractor's employer. Third question that has been raised is that there are defined settlements. In those settlements, we have formulated the scale of pay or wages payable to the contract laborers. And there are, in all those settlements, there is a clause that during subsistence of this settlement, you cannot agitate any other issue with regard to your regularization or the scale of pay. What they wanted to say, as you have approached before the Deputy Labor Commissioner for settlement, for fixation of our wages in terms of the principal employer, it is inconsistent with the settlement arrived from time to time. For that purpose, my lord, they have referred Section 18 of the Industrial Dispute Act. They have referred.
Yes.
The sum and substance of that section is that when there is a settlement, most of it is a conciliatory settlement, then it is binding to all. Even if you are not a party. Even the newcomers who will enter in the job, they are also bound by this settlement. So you cannot raise any question whatsoever against this settlement. And as you have raised this question, it is your petition claim is not tenable. These are the 3 points where we have argued in that. Now, so for first point is let me consider the settlement question. Yes, there are settlements. Now, in that settlement, contractors were also not made a party. Those settlements, that was a settlement between the principal employers and the other unions. If I am not wrong.
I don't know.
Huh?
You tell me. You cannot put a question to me on
Yes,
facts.
I have done to me. Contractors are not made a party.
Contractor is not a party.
Your Lordship, come to page 36. Read petition.
What is the judgment who has given me this?
These are my judgments.
1984. Okay.
These are equal pay for equal wage, non-obstinate clause, all these things. Now, contractors are not made as a part, are not parties so far this settlement. But contractors will pay.
So which page do you want me to turn to?
Page 36 of read petition.
Yes.
It is a settlement of 2013.
Yes.
Yes, and Your lordship, the parties to the settlement on one side,
Yes,
manager, chief manager,
yes.
etc., etc. And in the representing union, all the union representatives. Here, if we go through the other two settlement also, similar thing. So I will not trouble your lordship by again repeating this. Huh?
Third one is not, third one is
All right. Now, in this settlement, wages payable to the, it was an agreement that the wages payable to the contract laborer, sorry, basic wages payable to the contract laborer should be at par with the basic wages of the employees employed by the principal. So for other allowances is concerned, that allowances are governed by this settlement.
By the
By
settlement.
this settlements.
By the settlement. So basically, the issue is with regard to the basic wages. Correct.
No, basic, it is agreed that the basic wages to be paid to the contractor worker is the basic wages that are being paid to the employees of the principal employer.
Correct.
But so far other allowances are concerned,
Correct.
that allowances will be governed by the settlement. So in that way, you can indirectly infer that the work performed by the contract laborer are same or similar. Not only this. Now, if your lordship go through their pleadings before the Deputy Labour Commission,
No, you see, the settlement, the first settlement was of 2010.
2010.
2010 settlement provided that the contract laborers will also be eligible to have the basic wages.
Wages of the grade 1 employees of the principal.
So the second settlement also provided the same. Then why didn't they, so why is it the disparity in the wages? I don't know.
Because of the other allowances, etc. Yes, there is a disparity is there. Because the, is that, I am very deeply obliged for your lordship. In the contract, in the ONGC, what happened, a person,
Oil India.
Sorry, Oil India, a person who enters in their job, they would get time-bound promotions. Initially, they will be on grade 1. Thereafter, after completion of 1 or 2 years or 3 years, I should not be sure, they will be grade 2. Thereafter, automatically, there will be grade 3, then grade 4, grade 5, grade 6, grade 7, grade 8. From grade 8 to grade 9, they require to have some departmental examination. Otherwise, performing same jobs, they will be automatically upgraded to their grade. And because of these upgradations, the scale of pay will differ. But so far,
but then they are grade 2, grade 3, grade 4. You will have to be considered to be grade 1 all the time, won't you?
Yes. I have to be considered grade 1 all the time. But they will be automatically promoted grade 2, grade 3, grade 4. So there are some disparities occurred. To mitigate this thing, what the Deputy Labour Commission has done, from considering the years of service, he has added some basic.
Can he do that?
Considering this thing, Millard.
But how can he do? Can he add something? You see, when the basic wages are provided, can he add according to the number of years? Can he add that if you have completed 5 years, this much, 10 years, this much?
I have to answer this question. So for that reason, Millard, I would like to invite your lordship to go through Rule 25B.
25?
25 2B.
25 to 5A. Yes.
Oh, yes. 5A. In case where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wage rate, holidays, hours of works, and other condition of service of the workman of the contractor shall be same as applicable to the workman directly employed by the principal employer of the establishment on the same and similar kind of work, provided that in case of any disagreement with regard to the type of work, the same shall be decided by the labor commissioners. So labor commissioner has some discretionary power.
No. You see, the issue is this. If, say, you are a grade 1 in some particular line, when you become grade 2, you are still in that line.
Yes.
And your grade 3, you are still in that line. Does your work change just because you are grade 1 and grade 3? Doesn't change.
Does not change.
Then that is for a regular employee. The pay
But
scale,
they are
the pay scale of the regular employees will change
But the
according to their age, years of service.
but the pay scale of the workman contract labor will not be changed.
Naturally, because they have to get the
Though they
basic
are
wages.
performing same and similar nature of job.
Maybe. But then, supposing there is one grade 1, one grade 3, one grade 5 in that same line of work, why should the contractual employee get the basic wage of the grade 5?
Yes. Yes, I will answer this question. I will answer this question. Your lordship's query is that I am getting the grade 1 scale.
Yes.
As a contract laborer.
Yes.
My contemporary employee is getting grade 3 employees.
Yes. Supposing there are 4 of you are working, 4 persons. One is a contractual employee, and the other 3 are regular employees, but one is a grade 1, one is a grade 3, one is a grade 5. Now the grade 1, grade 3, grade 5 will be getting different wages. Naturally, great. So, and then you are getting the basic wages as the grade 1.
As I am getting the basic.
Now, why should you get the basic wages of grade 3?
Yes.
So you mean to say that your years of service should also be counted?
No.
Or
That is the issue before your lordship. So far, equal wage and equal pay for equal wages is concerned. Now, your lordship come to Article 39D of the Constitution of India. I'm sorry, I have taken.
No, it's okay. I have taken my copy.
Yes, sir.
It's okay. At least I've got my own file here in front of me. No, where's the one copy for him?
All right, no problem. I have control. Article 39D.
39D, yes. The state shall direct its policy towards securing that there is equal pay for equal work.
Yes.
Okay.
So it is in the directive principles.
Correct.
So it is not enforceable.
Okay. Then
In view of Article 37, it is not enforceable. When there is a law in terms of these provisions, it will be enforceable.
Correct.
Now, all those judgments, I will refer one judgment before your lordship. Before referring the judgment, I will just trying
No,
to.
I just want to know one thing, like what I meant to say was, maybe you
Yes.
didn't understand. Supposing there's a security guard.
Ah.
Security guard, there's a grade 1 security guard. And a person, some other grade 2 security guard, some maybe grade 3 security guard.
Doing same job.
So they're doing all the same job.
Ah.
But these are all permanent employees of the oil industry.
All England.
Now they will be getting their wages as per their pay scale. So a person who has been working for a longer time, who has been promoted will be grade 2, he'll be getting a higher pay than the grade 1. Similarly, a grade 3 will be getting a higher pay than the grade 2 and grade
Yes.
1. Now, why should a contractual employee who is also doing the same job as a security guard get the pay scale or the minimum wage of that grade 2?
Why should not?
Yes, because
Yes.
grade 1 is also doing the same
Same
job, grade 2 is also doing the same job, grade 3 is also doing the same job. Then why
And
should
that-
he get, why should the contractual employee get the pay scale, I mean the wages of a grade 3, minimum wages
Their
of grade
arrangement because of this settlement.
No, I'm talking settlement is not a problem. I'm saying because of now the DCLC in his impugned order, has now taken the wages that is applicable to
As much as possible,
uh,
he made an endeavor
uh,
to
and
bring
he
a
added
parity, bring
he-
a parity
added-
as much as possible.
he added 3,000, 5,000 here and there.
To have a parity, not identical, to have as much as possible. He has stated in his order itself.
I don't know if
Otherwise-
I don't know if I'm making myself clear. I don't know. Are you getting more confused? Or, do you understand my question, Mr. Goswami? You don't understand.
No, what your lordship wanted to say.
I understand to the extent that your lordship is thinking of a regular employee
Yes,
who is first inducted to grade 1.
yes,
And then how does he go to grade 2 and grade 3?
yes,
That is a promotion.
yes.
It is not automatic.
Here in this case,
No, it is not automatic.
Yes.
Because they have to face a assessment to go to the.
that's what. So what I'm saying is, but the nature of job remains the same.
Same.
Same or
Security
even-
guard who is a grade 1 will do the same job as a security guard who is 2 and 3.
Yeah.
Won't they? So my question is,
I understand that there may be some supervising power as
No.
you go up.
if there was, that's a different issue.
That is different.
That
Now,
is
if
what
there
I-
is no supervising, because you said, as per every job, there is, it goes up to grade 8 and then grade 9. So grade 1, 2, 3, now grade 1 is a different pay scale, grade 2 is a different pay scale or what?
Correct.
Is a different pay scale.
Yes.
Grade 3 is a different pay scale.
Correct.
Now, if grade 1, now if they are all doing the same amount of work, a similar kind of job, grade 1, grade 2, grade 3, a contractual employee, why should he be considered to be a grade 2 security guard after a few years, completion of certain years? Why shouldn't he still remain stagnant as a grade 1?
So in order to bring some parity or in order to remove this stagnation, the Deputy Labor Commissioner had added some wages. If you also come page 66, security guard at 2. Page 66. Read petition.
Yes, I've got page 66.
Yeah. The category is security guard. He has examined in what
Yes.
manner.
Yeah.
Statement of Dilip Shaikia, security guard WC number 1. During the inquiry, he stated that he has been working under such and such while contractor in the establishment of Oil India Limited Duliajan since 2000. Before this, he was WCL workman since 1994. 94. His T number is 1059, which was allotted in the year 2000. After signing of MOS on 19/4/2000, 19/4/2000, consequent upon become contract workman from 2001/2000. He is posted engaged as security guard in Well India Hospital. He is performing the work of opening and closing of wards and cash sections of hospital. His educational qualification is 9th class plus. Total duty performed by him as per day is 8 hours, shift wise 5 a.m. to 1 a.m. or 1 p.m. to 9 p.m. or 9 p.m. to 5 a.m. He is getting 4 days weekly off in a month and getting the wages of rupees 874 per day. His payment made on monthly basis depending upon the number of days in a month. In this way, his average wage is 26,231 per month. He is getting 7 days casual leave, 21 days leave with wages in a year. He is also entitled 16 days company holidays, including national holidays. He is getting 16% bonus in a year as per company rules and terms of settlement, and 2% annual increment on basic wage. His provident fund deduction is also being made. He is mentioned that the permanent security guard have also been deployed in the company hospital. Permanent. Since the security guards of the permanent role of Oil India Limited were also found to be engaged in the company hospital, so it was decided to take the statement of one of such employee which is mentioned below. Statement of Sri Bhogeshwar Das, security guard. He stated that he is a permanent employee of Oil India Limited, working security guard in Oil India Hospital, Duliajan. He has been working as a permanent employee in the establishment since 1994. He has to perform 8 hours of duty per day, shift wise, such and such. He is getting approximately 80,000. 80,000 per month. And we are getting 21,000. 26,000, no? 26,000. Per month, including allowances. His duty is open and close the office rooms. Yeah, same duty, Miller. He is 9th class pass, same qualification. In respect of leave, he mentioned that he is entitled to 30 days paid leave, 10 days casual leave in a year, 4 days weekly off in a month, and 19 days company holidays, including national holidays in a year. Bonus is not being paid to him, but he is getting performance-related pay, PRP, annually, which was rupees 40,000 plus 28,000, that is rupees 68,000. During the financial year of 2016-17, his PF deduction is being made as per company rules. So far as the other facilities are concerned, he is getting medical facility, self and dependent family members, HRA, in class of non-allotment of quarters. Further, he stated that he was earlier a contract labor. He was like us, contract labor, and company regularized him as permanent workman in the year 1994.
No, this Bhogeshwar Das, he's a grade 1, grade 2, what? He's a permanent employee, so what is he?
Grade 5.
Grade 5.
He's 65.
So he's grade 5.
Grade 5.
So why shouldn't the pay of a contractual employee be considered with respect to a grade 1 employee's pay? Why should it be grade 5?
Yes. That is the question. Now, this is because of the because of the provisions contained in Rule 25.
What does it say?
Again, let us come.
If-
25,
Yes?
Rule 25, 5A, contract level.
Yeah.
In case where the workman employed by the contractor perform the same or similar kinds of work,
Correct.
not the grade.
No, not the grade. But no, same and similar. But a grade 1 security guard will be doing the same job.
Yes.
Why shouldn't your pay be compared with the grade 1 security guard? Why not? If it is, then if it, as per your understanding, why shouldn't it be compared with a grade 8 security guard? Why grade 5? Why stop at grade 5?
No, the figures were available at that point of time.
My question is, if a security guard can become a grade 8 security guard or a grade 7 security guard,
Doesn't make no difference again.
why did the authority stop at grade 5? Why not grade 6? Why not grade 7? Or why not why did it not stop at the grade 1?
At that point of time, he was available there, Lord. Now,
But okay, supposing now there's grade 1 available, then will he change his mind?
anyway,
No, I just the questions coming.
Yes,
I'm still trying to grasp the issue.
so your lordship's query is that as he is working.
You see, what is the pay scale of a security guard? Anyway, is the pay scale or a fixed pay?
No, so for our
permanent.
our case is a fixed pay.
For a permanent,
Permanent there is a scale pay.
the scale pay.
Scale pay. Total emoluments is much department.
What
So
is
in
the
order to-
what is the pay scale of a grade 1 and a grade 2? Do you have it?
Now, as per my instruction, there is no grade 1 employee.
There's no grade.
No grade.
There-
All
there
of
is-
them are upgraded.
Okay.
There is no grade 1 employee in
So there's no grade 1, there's no grade 2, grade 3,
Grade-
nothing.
grade 2, grade 3 may be available, but there is no grade 1.
No, but a security guard, supposing a security guard is appointed on a permanent basis, does he get promotion to grade 2, then to grade 3 or grade 4, or does he come directly from grade 1 to grade 5? One by one.
One by one.
If he goes one by one, then if the pay scale is the same for everyone, I mean if the pay scale is different for everyone, the contract employee, his wages should be compared with whom? The highest or the lowest?
Low, highest can be
Huh?
similar work. Basically, it's a similar work.
So similar
But,
work.
but actually, what happened here, the deputy labor commissioner has not awarded the wages of 3,000. He just making comparison. And after comparing the.
No, that's what I want to understand. I want to
Yes, yes,
understand
yes.
the basis of how that labor commissioner has come to a finding that the basic wages of that grade 5 security guard should be taken
Yes,
into
yes.
consideration.
So let us read this.
Mr. Das, are you also in this issue? The issue is here. No. When you come to, you see, when you come to, okay, grade pay now.
Grade 4, they compared with.
When you come to page 65, you see security guard grade 5, junior assistant grade 5, operator of operation grade 8. So then junior engineer grade 9. So there are different grades. So if there's a security guard of grade 5, my question was if there's a security guard of grade 1, and if there's a grade 1 security guard who is doing the same job as a grade 5 security job guard, but who of course has got promoted due to his length of service or whatever.
End of service.
Now why should a contractor, a contractual employee
be considered against the wages given to a grade 5 security guard? Why not against the lowest?
Actually, at present, there is no grade 1 employee. Anyway,
No, but at that relevant point of time.
that will be.
I don't know if my questions are
No,
are relevant or not, or
no, very much,
at
very
least the
relevant.
bus
What-
or what.
Yeah, what your lordship's anxiety is that all these contract laborers are getting the basic wages as being paid to the grade 1 employee,
Grade 5 employee.
contract workers.
Huh?
Contract workers.
The contract workers are getting the basic wages that is applicable to grade 5, grade
no.
6, grade 3,
No, grade 1.
grade 1.
Grade 1.
Oh, is it?
Yes, it is admitted position.
No, that is not what has been projected.
Yes. Yeah, if you come to a settlement.
Not the settlement, the impute order. Settlement is as per the grade 1.
Yeah.
But because they're not happy with that, they have come and raised the dispute. Now, when this labor officer went and took evidence, he took the evidence of the contract workers plus those grade 5, grade 6 permanent employees of Oil India and applied their wages for the wages of the contract employees. That's what I've been
Yes.
told.
Now, what he had done,
Huh?
Page 65 clearly indicates.
what he had done, so far the contract laborers are concerned, their basic wages is fixed as the grade 1 employee. But he has added something.
No, added maybe. Yes, added, that is,
Some-
that's another issue. Adding that another issue. Now I want to know, what is the grade 1 security guards pay scale, grade 2 security guards pay scale, and the minimum wage for grade 2, same for grade 3, grade 4, grade 5. So that I can,
Yes,
that I can know,
Yes.
because he has applied, I think he has applied that 2769.
So that can be being.
Wait, 2769, page 58. Page 58, he's taken the grade 1. He's not taken grade 3 or 4 or 5.
Yes.
He's taken the pay scale of grade 1 and paid and given the minimum wages of grade 1.
Yes.
Correct. Page 58.
Yes. Only grade 1. Yes.
This is the minimum wages for grade 1. So now the issue is, if the basic, the gross, that is the gross salary. Now, in the settlement provided in 2010 and 2013, what was the amount to be given to the contract workers? Let us see that
Yes.
in the settlement.
Page number 35, no? Page 36 for like one settlement. No, 2010 to 30 or 6.
Page 37,
32 without
32.
wages basic. The starting basic pay of grade 1 of the company's regular employees,
Yes.
presently 4,800 per month. At that time, 2010.
Okay, at that time it was
Will
4,000.
be paid to listed WCL. As and when this basic pay is revised for the company's regular employees, the same revised starting pay of grade 1 will be made applicable to the listed WCL with effect from 1/1.
2010.
So if the regular basic is increased, automatically
They will get
it
there.
will be done. Brilliant.
So they're getting the basic anyway.
And
Yes.
yeah, yes. That's what I said, that it was
They are
introduced
getting
in 2010. itself.
Okay, 2013, let us see.
So 37.
Yes, it is a page 37.
Yeah.
The starting pay of grade 1 of company's regular employees, 9,300 will be paid.
Hmm.
As and when this basic pay is revised for company regular employees, the same. But this is only for, one was for listed WCS and this is for unlisted. So they are going to get the basic wages.
Only basic wages. That too, for the grade 1, they are, though they are performing 20 to 25 years of service, but they will get the basic pay of grade 1 employee. That is the problem. Whereas their contemporary will get much more. So in order to bring this, reduce this disparity,
But then that is a different aspect. That is not with respect to parity of pay. That is with respect to the, he's trying to make giving some consolation to the service condition due to the long years of service.
Yes.
Due to the long years of service, is giving them some extra benefit.
Even in the latest, at page 137, the same position. It is increased
This
and it-
explanation will be available at page 67. Page 67.
Page?
67.
Yes.
Paragraph 2. Hence, there should be some sort of parity between the contract laborers and the permanent employees performing the same nature of job in terms of at least wages to the possible extent. To the possible extent. A tradesman or attendant grade 1 on the permanent rule of the company gets 27,629, inclusive of basic pay and all allowances at the time of recruitment. Whereas the contract worker, WCL list 1 is getting approximately 26,231 after 17 years of service. After 17 years of service, which is glaring example of acute injustice. Their duty hours are also same. As such, it will be in the interest of the justice that contract workers in the category of WCL listed 1 working as a security guard, figuring in the claimed list of the union are given 27,629 towards the wage.
How does he come to a finding that contract workers get approximately 26,231 after 17 years? When the settlement provides that any contractual worker who is working will get the basic minimum wage, and even that will cover even future contractual employees. How does he come to this, that after say, okay, so that means on the first day, how much would they get?
Yes. For the
If they get, say, after 17 years, if they get 26,231, on the first day, how much would they get? At the time of joining, how much would they get? In terms of the settlement?
Actually, in every settlement, basic rate is fixed. In every settlement, basic rate wages is fixed. And in addition to that, there are some other allowances that depends upon the job. Basic rate wages for all contract workers are same. Whether he has performed 20 years of service or 5 years of service.
It will be the same.
It will be the same. It will be the same, but their other allowances may differ.
Now, what is happening is, okay, there is a slight difference of around 1,000 rupees, that is there.
Slight difference.
Slight difference of 1,000 rupees, which should be corrected, no doubt, because if it's the minimum has to be given to the contract worker. But how does he add all these 5,000? That means a contract worker who works for 5 years and one who works for 20 years, depending upon the length of service, they will get,
Same basic wage.
huh? No, they'll
Basic
get
wage will be
extra 5,000. A one-time fixation, huh? Per month they'll get, per month.
27,620
Why should-
as the wage,
Um,
plus 5,000 as one-time fixation benefit per month, taking into account their seniority in the service as well as the nature of job and the skill acquired over the years, years. So for the security guards in the category of WCL, listed two.
But when, you see, because in this judgment of state of Punjab versus Jagjit Singh,
Yes,
it was said that they would be entitled to draw wages at the minimum of the pay scale.
pay scale.
There is no question of addition of 5,000 or
No,
3,000.
here actually they have no pay scale.
Huh?
So far the contract laborer is concerned,
No,
they
no.
have no pay scale.
No, so they will take the pay scale of the regular employee. The minimum regular pay scale given to a regular employee will be applicable to them.
Yes, no. So far, that case is concerned. So far, that case is concerned, because probably I have not been able to convey my. So far, that case is concerned, there is no such act. What happened in this case? They have applied Article 14. By applying Article 14, a group of people have been segregated from the other groups. This group of people are who are the casual employees.
Okay, let's come to page 75. I just want to, I'll let you make submission later. But just let's clarify something. Page 75. How
If I place the judgment, that will be clarified.
Yeah, yes, but let's look at page 75.
75. After perusal,
yes.
after perusal of the above statements of contract workers and the permanent employees, it is a fact there is no similarity of the job contents of the both types of workmen, but it has also been established that there is similarity in the job contents of those workmen to a great extent. With the
Now, this is very subjective. What he has said is very subjective. To a great extent means how much? 70%, 51%, 90%, 100%, 99% what?
but he had arrived this conclusion after taking evidence on at least 27 workers. 13 from the contract laborer, 14 from the permanent employee. And he has recorded all this evidence here. And after recording the evidence, after appreciating the evidence, he has come to this conclusion. His conclusion is not arbitrary.
Okay, carry on. The contract workers.
The contract workers categorized as WCL listed 1, 2, and 3 in the shops and sections like production well, production SS, production gas, field communication, electrical engineering, material, civil, well, gas, production services, etc. are working since long and have acquired sufficient skill and knowledge of their work. They have worked in other shops and section also, so they are having varied work experience. They have proved their utility by helping the management in the core activities of the company, wherever engaged. The permanent employees may have different nomenclature. So far, their designations, that is very much important. Permanent employee has a defined nomenclature. So far, their designation is concerned. But they are performing almost same type of job.
Almost.
Almost same type. That is why so far
No,
Rule
no,
20
the almost same type of job does not mean same.
No, It is not same. Almost same means similar.
No. Almost same doesn't mean similar.
Yes.
Where? The word, let us look at the dictionary, what is the meaning of the word similar?
I will replace this. I will place some other judgment that will clarify this. 2018, 12 SSC. I will
Okay.
place it.
Yeah.
Yeah, after finishing this thing, I will place it.
Then,
This aspect has been
so one thing is
2008.
almost same type.
Almost same type of job.
Almost same type of job is not same type. That's very clear.
Yeah, yes, not same type, but similar type, maybe.
Maybe similar type.
Similar type. If this is similar, then also they are entitled.
But it has to be, you see, similar. The degree of similarity will also be required.
Yes. And for that,
the degree of similarity may also be required.
yes.
Like you can say a healthcare worker and a doctor are doing the same job. It's slightly similar because they're both caring for patients. Now, what is the degree of care given?
Yes,
and the specialization required, that's different. So that has to be clarified.
That has been examined here.
Okay.
That has been examined by taking evidences. And after examining this, he has reached this conclusion. If required, I shall go, I have to go through that portion of
Yes.
which will have evidence to. The permanent employee may have the different nomenclature so far as their designation is concerned, but they are performing almost same type of job as that of the contract workers. The duty hours of the contract workers are same in comparison to the permanent employees. It was also observed during the inquiry, Miller. Here he has taken the evidences. During the inquiry, that permanent employees, although supervising the work of contract workers, permanent employees, contract workers in some cases are also doing the same work as a team, and there is no differentiation in the nature of job of these workmen.
So there is a slight
There
difference.
are some workers.
No, you see, no worker is doing any supervisory job.
But
Only the
some of the permanent workers.
only the permanent workers are doing supervising job.
Some of the permanent.
Yes,
Some.
You see, and doing the work of a contract worker, I mean, I've got a gardener, but I do gardening also. That does not mean that, but I supervise also.
Yes. No, let us read.
So you've got to understand the nuances. A person might have a restaurant, own a restaurant, and he has got waiters. He might also serve. That's a different thing. So, I mean, you cannot, anyway, carry on.
For that purpose, your lordship can come to page.
No, I'm just,
A statement recorded, as your lordship.
Yes, page
67. This will clarify.
Yes,
He has taken the evidences.
yes.
Medical attendant, as your lordship just now pointed. Statement of C. Provod Dekar. He submitted that he has been working in the establishment as a contract labor since 1987. Thereafter, WCL1 worker since 2000. His key number is such and such, which was allotted in the year 2000. After signing of MOS on 19/4/2000, his nature of work is helping. Here is important. His nature of work is helping the patient, and when they need oxygen, CT scan, X-ray, ultrasound, and also bed at maintenance. These are all medical attendant used to perform these things. His academic qualification is 9th class pass. He performs his duty 8 hours per day, shift-wise. That is 6 a.m. to 2 p.m., 2 p.m. to 10 p.m., 10 p.m. to 6 a.m. In respect of leave and other benefits, he stated that he is entitled for 7 days casual leave, 21 days leave with wages, 16 days company holidays, including national holidays, 16% bonus on basic pay in a year. He is getting approximately rupees 26,231 per month with 12% with 2% annual increment on basic wage. His PF deduction is also being made. He also maintained that the permanent medical attendants have also been engaged in the company hospital. Now, statement of the Pradeep Chandra Chetia, who is a permanent medical attendant. He stated that he is working as a permanent employee and posted of and in the post of paramedical technician, SG8, on the role of Messrs. Well India Limited Duliajan since 1995. He is a grade 8 paramedical technician having Well India Limited number such and such. His duty is to help the patient as and when they need oxygen, CT scan, X-ray, ultrasound, bed maintenance, same as being done by contract laborer. He performs his duty 8 hours, day shift wise, 6 a.m., 2 p.m. to 2 p.m. to 10 p.m., 10 p.m. to 6 a.m. His academic qualification is 10 plus. Plus, he getting approximately 1,20,000 per month. He is in per month, including all allowances. In respect of leave, mentioned that he is entitled for 30 days paid leave, 10 days casual leave in a year, 4 days weekly off in a month, 19 days company holidays, including national holidays in a year. Bonus is not being paid to him, but he is getting performance-related pay annually, which was 25,000.
Okay, he should get same minimum wages, that's all.
Same.
But where does the plus 5,000 plus 3,000, that aspect?
That aspect has to be clarified.
We have to deal with it.
We have to deal, that will be.
Then, carry on reading, page 75.
Let us read page 75.
The inquiry was conducted on random sampling basis.
Why inquiry? Page 75.
Yes, page 75, bottom, right side it starts, the inquiry. Inquiry.
Yes. The inquiry was conducted on random sampling basis. It has also come to the notice of the authority that there are many field stations of the company where the contract laborers are not performing the same job as being done by the permanent employee. So there cannot be any comparison in respect of the job contents of both types of the workmen engaged in these stations. As such, the justice demands that the contract workers in the category of WCL listed 1 performing the job of cleaner. What are the jobs? Not for all jobs. Cleaner, helpers in shop sections, in the production, oil production, production gas, field communication, electrical engineering, material, civil, well, gas production, service in Well India Limited Duliajan, figuring the list of the union of the should be given rupees 27,629 plus towards the wage of plus 5,000 on account of one-time fixation benefit.
What is this one-time fixation? It means every month.
Everyone.
This is one-time fixation now. How is it possible? I want to know.
Actually, so far the
Because pay
basic,
fixation of the permanent employee is done.
the permanent employees are getting.
Now, who is he to give a one-time increment or whatever? How can he give an increment when the Supreme Court also has not?
No, towards the wages on account of one-time fixation benefit.
Yes.
That is basic wage.
No, plus 3,000, plus 5,000.
No, so far,
That you come.
so far as the contract workers category of WCL is performing the job of cleaner. Only.
To whoever he has given that plus 5,000, plus 3,000, I want to know if he can give that does he have the power to give it?
No, he has a power,
As per the act,
he has a power,
as per the act,
he has a power to give the equal weight,
equal weight,
equal weight.
not,
And if-
not, can you give a one time?
equal, but if we consider this weight, it is far below the equal weight.
No,
Yes,
equal weight
because-
is 27629 is giving, minimum pay scale.
Because the regular employees, madam, they have this, they can achieve this promotional benefits, performance related pay.
Right.
Contractual labor cannot get it.
So?
That is the reason why that.
40,000.
1,000, 3,000. That will be it.
Yes,
That will be it.
performance related.
Okay.
40,000, no?
Yes, you can start your submissions. Let's-
Okay. Giving.
How long will it take, Mr. Das? Because Mr. B.D. Das has to start after you.
So far facts is concerned, if your lordship has some any other
No,
inquiry, then I can answer. Otherwise, straightway I can go to the law point.
one aspect is,
If your lordship has any
did, did,
inquiry,
did the labor officer, did he did he give any opportunity of hearing to the principal employer?
yes, he has heard the employees of the principal employer.
Supposing you have to pay the employer, you have to pay the employee. Would it be proper that for your juniors fees, they don't ask you, but they ask your juniors?
Yes, I have got your lordship point. But that can be answered easily, my lord. I will answer this point. I will answer this question. For that purpose, your lordship has to go through their objections. In their objection, they have not denied anything, that they are not performing similar job.
They are not?
They are not performing the similar job. Only question that they have raised in their answers, that is in the writ petition itself. Only question they have raised, there is a settlement, you cannot demand it, and you cannot demand equal pay for equal service. That is it.
Where
So
is
the
the-
performance is concerned, what content is concerned, they have not denied.
Where is that? Where is that?
That has to be ascertained from their annex reply.
Page?
Page 50 probably. 5 years. 50. Page 50 onwards, I have to read entire thing, then you can start it.
Huh?
50 onwards.
50 onward.
Okay, we'll skip. Some paragraph I can read it.
No, you read whatever. You have to do justice to your
Time.
client.
Yes.
No problem.
Now here, before reading this thing, what I would like to convey to your lordship is that initially we filed an application before the Deputy Labor Commissioner. The Deputy Labor Commissioner sent a notice to the principal employer to submit their reply. They had submitted their reply. In that reply, they have stated that you cannot raise this dispute, this claim, because of this settlement, mainly because of the settlement. They have not disputed about the job contents, whether they are similar or identical, all these things are not there.
So you mean to say that after the evidence of those workers were taken,
Both the
then-
sides of workers.
Huh?
Both sides of workers.
Both sides, after they were taken, then the principal employer was asked about his views. Is it? is it your case that after the evidence of those workers were taken, contractual workers and permanent employees, after the evidence was taken, the principal employer was asked his views on the evidence taken by you,
No, no,
by the,
that is not the case. That is not the case.
so,
Well, what he had done,
so.
he had considered the representations. Thereafter, initially he deputed one other officers, other officers,
To do what?
to assess these things. Then the
So
other
who took the evidence?
Deputy Labor Commission.
He himself took the evidence.
The assistant officers, he went to the spot and he found that these contract laborers are working in defined perennial jobs and defined manufacturing jobs, which are essential to the workers, industry. And he submitted his report. Then the Deputy Labor Commissioner was not satisfied with his report. Then he went to the spot and he stayed there 3 days. And he called all the contract laborers and other permanent workers. And then he has recorded their statement. And after recording their statement, he gave this finding. And he has also considered their pleadings before these things. Now, if your lordship go through the procedure, there is no such procedure has been contemplated how to conduct an inquiry. And that aspect of this case was assailed in the Supreme Court.
Okay.
That is reported in 1974. That aspect of the case was examined. Justice A.N. Roy judgment.
Yes, just show me that. That's an important issue.
That is important. Gamon India. I have proven.
Okay, you're doing it.
Copy diya. Copy diya na, hindi?
No.
Sorry. I'm giving. Copy did you? Citation is 74.
Not here. You gave me only, okay. Is it here in this bunch?
Yes.
Okay.
74 1 SCC page.
Wait, after they've given me so many. 1974. 1 SCC.
1 SCC. Here, this provision has contained it. If you go to the entire judgment, Miller, probably you can visualize the situation in a
Oh, you mean that it has to be a due process of reasoning has to be made to come to the submission made by you.
No.
Then where does it say that regarding the procedure to be followed?
There is
by
no such procedure.
So
It is a summary proceeding, and for that reason, this rule was challenged.
Okay.
In the Supreme Court.
Okay.
Supreme Court said, no, it is a valid rule.
Okay. The rule was challenged on the ground that no procedure has been given in the rule. Is it? Where is that? Where does it say that?
Okay. Paragraph 30, Miller.
Paragraph 30.
30.
30.
Provisions.
Yes.
Provisions contained in Central Rules 25(5)(b) are challenged as unreasonable. Rule 25(2)(a) states that the wage condition of service of workmen who do the same or similar kind of work as the workmen directly employed in the principal employer's establishment shall be the same. In case of disagreement with regard to the type of work, it is provided that the same shall be decided by the Chief Labor Commissioner. At that point of time, it was vested to the Chief Labor Commissioner. Subsequently, it has been vested to the Deputy Labor Commissioner. Chief Labor Commissioner, whose decision shall be final. Rule 25(2)(5)(b) states that the other cases, the wage, rates, holidays, and conditions of service of the workman of the contractor shall be such as may be specified by the Chief Labor Commissioner. There is an explanation in this clause that while determining the wage and condition of service under Rule 25(2)(5)(b), the Chief Labor Commissioner shall have regard to the wage and condition of services in similar employment. That has been done here. This is reasonable. The complaint against 25(2)(b), 5(b), in that case, that there is no provision for appeal. It is not difficult to determine and decide the case of this type. The Commissioner of Labor has special knowledge. It will be a question from a statute to statute, from fact to fact, as to whether the absence of provisions for appeal makes any statute bad. The provisions contained in 25(2)(5)(b) refer to wages, hours of work, and conditions of service in similar employment. A person for appeal is not flexible. This issue is simple here. A long-drawn procedure may exceed the duration of employment of the workman. A proper standard is laid down in the explanation to Rule 25(2)(5)(b). The absence of a provision for appeal is not unreasonable in the context of the provision here. The Commissioner shall have due regard to the wages of the workmen in similar employments. The parties are hard, and the Commissioner of the Labor, who is specially acquainted with the conditions, applies the proper standard. There is no unreasonableness in the rules. The petitioners contended that in the third place that the provisions contained in Section 14 of the Act with regard to the forfeiture of the security are unconstitutional. Section 12 of the Act provides that no contractor and no shall undertake, execute any work except in accordance with the license. And further that license.
No, where does it talk about the procedure? The challenge to you are saying that the said provision was challenged on the ground that it did not have a procedure.
But ultimately, this provision has been declared as a valid provision.
No, okay.
One of the ground was that there was no appellate provision.
That was that. You see, the
provision.
The provision is valid, but there is no challenge to the provision on the ground that there is no procedure to be followed by the
yes, that is,
by the Labor Commission.
that is not at that.
That is not there.
Not in there. But the provision is
Valid. The provision is valid.
yes,
No,
summary proceeding. Summary proceeding, there is no such hard and fast rules.
This is summary
But
procedure.
there is summary proceeding. That the petitioners contended that in the third place, that the provision contained in Section 14 of the Act, okay, that is not very relevant here. Now let's come. On behalf of the petitioner, it is said that Rule 24, which fixes the fees 30% workmen void under Article 14 and 19(1)(f), arbitrary sum. Secondly, this said Act, there is no obligation on the government. These are not very. It is with regard to the other provisions of the Contract Labor Act.
Where does it say the summary procedure?
Summary proceeding is not specifically stated here, but so far the rule is concerned.
You are saying something, Mr. Senior Counsel.
No.
Where
It is a summary proceeding, it appears from the rule itself.
it does not say in this judgment that it
No,
is a summary
judgment does not say. Judgment has said.
because you see, once you say something, you are a senior counsel, so we have to believe it.
No.
We believe it.
No,
Then
summary by senior counsel also says that is a summary proceeding. Just now, here's argument.
no, Maybe a summary procedure, but it's not written here.
It is not that I wanted.
No, it's not written here.
It is not written here, but my senior counsel has also argued that it is a summary procedure.
So is it a summary procedure?
No, I said that it can be a summary procedure adopted, but there has to be some.
There has to be a procedure.
Yeah, there
It
should
is
be-
summary, it is summary.
And that is. said
But
by
then,
this judgment also.
But then, there has to be some kind of, guidelines or something which has to be followed. That's what he said, okay. So we have to see whether
Whether the inquiry conducted by him
was fair.
was fair or it is arbitrary
Ah.
based on no reason. One thing, and whether the principal employer were agreed by any other not following the procedures. These three things are to be looked upon. Now, one thing that I would like to say before your lordship, a proceeding has been drawn. Somebody has come to a person lodging some allegation against some persons. The person concerned issued notice to that person. You see, some allegation has been lodged against you. So what is your content? What he would like to say? He has submitted his reply. And in that reply, if we see that whether he has said anything whatsoever, that these contract laborer are not performing same and similar jobs. He has not said so. Yes, the true statement has been made. And that is before your lordship.
What was the letter sent to the principal employer? Page?
Page 50.
This letter to?
Deputy Chief Labor Commissioner.
No, letter from the DLC, from the DCLC to the petitioner. Where is that? Any notice, anything? Where is the notice sent to the petition?
Page 45. Demand of same and similar wages and facilities to the listed, unlisted workmen laborers of Oil India Limited division regarding. Please refer to this official letter event number dated 3/7/2015 on the subject cited above. You are requested to submit your comments in quadruplet along with the list of 2559 WCL laborers, nature of job within 7 days from the date of the receipt of this letter of taking further necessary action in this matter. No. Yes. Reply will also be find at page 46.
Yes.
We acknowledge. We on behalf of the Oil India Limited, let us keep up some lines. We on behalf of the Oil India Limited OL submit our comments in reply as under. As per the available records and few recent representation made by OITSS before Oil India on various occasions, it is understood that OITSS have been formed as a union of few contract laborers. We would also like to inform you that WCL work contract laborers are contract laborers only engaged through the contractors in OIL under various contract awarded through the tendering process. That the WCL have been engaged by the contractors after obtaining labor license under the Contract Labor Regulation and Evolution Act 1970, the Act, and deployed under the various services in Oil India Limited as per the requirement and are covered by the Act and the rules thereunder, while being the principal employer has been discharging its duties and obligations fully in accordance with this Act. it appears from the letter submitted by OITTS before you that they have demanded same and similar jobs under under Rule 2525B of the Act, which is totally misleading. In this connection, we would like to mention the Rule 2525 Act that provides for payment of prescribed minimum wages and any wages fixed by the agreement or settlement or award or contract laborers. We would further like to submit that there are two numbers of MOS entered with the union of all WCL's contract laborers by Well India Limited before the RCL Central Dibrugarh, and which are presently in force. The copies of the settlement executed for extending various benefits, including increases in wages with unions of contract laborers in the year 2006, 2009, 2010, and 2013 are enclosed herewith for your kind reference. That we further submit that the service condition and benefits, including the leave with pay, holidays, rate, basic wages, which are higher than the prescribed minimum wages by the appropriate government. Medical allowances, overtime rates, bonus, etc., have been finalized under the aforesaid settlement against the demands raised by the contract laborers from time to time, and OIL has been duly discharging its obligations under these settlements toward the service condition. That in this connection, we further submit that the basic wage rate under the states, these settlements have been fixed at par with the regular grade 1 workmen. That they have stated, workmen depending upon the nature of work and in consonance with the Rule 2525 of the Act, and Well India Limited has been complying the same. Well India is a government company and has to follow the government guidelines, including the sanctioned post and prescribed from time to time. That we further submit that the list of certain numbers of contract laborers were made after various settlements entered with the Contract Labor Association unions. The only purpose was to ensure proper discharge of the benefits of this WCL by the contractors. The list as available to the Well India Limited with the details of WCLs made subsequent to the memorandum of settlements are enclosed herewith for your kind reference. All these WCLs are being engaged by the contractors for various miscellaneous works as instructed by the respective contractors. In this regard, we would further like to inform you that OI.
No, I want this, you see, where is this letter dated 3/7/2015? At page 45, it is written, please refer to this office letter dated 3/7/2015. Where is this letter?
That is with them, it is not with us. It is not with us. This letter was written to them. They have enclosed this letter.
Yes, where is this letter? 3/7/2015, which is mentioned at page 45.
Page 44. Page 44.
Page 44. Yes, page 44, it is there.
Page 2, yes. 3/7 to, yes, page 44.
No, this is not the letter.
Actually, what happened
No,
here,
no,
I have
no, not
checked up.
3/44.
Look, they have wrongly stated 3/7/15. If your lordship goes to the reference number, GR such and such number.
There is
GR
no,
45.
at page 45, there is no number in this.
No.
Reference number, there's no reference number.
Page 44, 3/7.
No, why?
15.
It is there mistakenly.
3/7/15.
Yes, if your lordship comes to the reference number, reference number GR 45 within, got it? Page 46.
Page 46 is the letter dated 3/10/2015.
But that should not be sheet and 27. Okay, that should be That should be 7/8/2005. It is apparent from the reference number.
Page 46 or reference to server.
Hmm.
Page
The
46.
46 is a letter written by Oil India Limited to the DCLC
With reference to the,
with reference to letter dated 3/7/15.
no, 37, reference number, letter number, your lordship.
Yes, letter number. Where is this letter number?
Letter number, your lordship will get page 45, same number.
But
GR,
then this is, please read the contents of page 45. Page 45 says, please refer to this letter, office letter, even number. And please reply to that. Now, this page 45 does not say anything. What is to be replied to? So where is this letter dated 3/7/15?
It's in process, my lord. 45. Nine. Actually, what happened, we wrote a letter to the Deputy Labor Commissioner on 3/7/2015. That letter is here at page 44. Probably they are referring with that letter.
But they have said office letter.
They have said,
And then when you come to page 46, it has got a memo number also. It's got a letter number at reference.
46.
The letter by the Oil India to the DCLC.
But this
refers-
memo number tallied with the letter dated. Letter dated 7/8/2015, page annexer 4. Same.
So I don't know, the petitioners have to produce this. I want to see what was the question asked in the first instance.
Yes, that will be relevant.
Yes, that's relevant.
I am also putting a question mark in my letter. While reading, I didn't find possibly. 46 is a letter from Oil India Limited to Chief Deputy Labor Commissioner.
Correct.
Dated 3/10/15. Reference your letter dated 3/7/15.
Yes, this 3/7/15.
This is, I said, this is not 44. I made a note, but I had put a question mark also. Because 44 is 3/7/15, all right, but I didn't say.
Yes, it is, and it is a letter by the union. The union will not have any memo number, I think.
This is the letter of.
Usually they don't have.
They use the number.
Only thing we have to find out if it is there.
It may happen on that very day they wrote this letter.
Yes, but they
On
probably
that
they
very
wrote.
day they wrote this
Yes,
letter.
but then that is not here.
That is not
That is
here.
the problem. I want to see what's the basis, what is the letter?
Query.
Here's the query. Was it with regard to pay parity or what? What was the issue?
Top content.
Yes, yes.
Page 46, that is subject is given, same and similar wages.
Yes, yes, I know. But I want to see what was exactly written.
Yeah. I don't think that's it. 50. Page 50 is our letter.
You might have wrote a letter on that day.
1050.
You are for whom, Mr. Pegu? For the DCLC. Then you will be having this letter that you sent to the petitioner. You bring it. I don't think he'll finish off. Huh? Yeah.
That letter was also with regard to same and similar, first paragraph kindly see. At page 46, our letter. We
Same and
acknowledge
similar wages.
in connection with the same and similar. While their letter dated 3/7. That 3/7/15 is for page 44. No, if your logic is trying to find out whether Oil India has said that this is not same and similar, in other replies, it is there below that page 52, 55, 57, 62. Page 52. Starting at page 50, oil stator dated 9/7/15. Demand for same and similar.
Where is
At
it?
page 50, Milord,
Yes,
Oil India's letter to
yes,
DLC,
yes.
page 50.
Para?
It is the subject, your letter number 10/6/15.
Okay.
Same and similar wages and facilities
Yes.
to listed WFCL Oil India Limited. Then they go and say that this is the letter, Milord.
No.
Huh?
No, nothing.
I think so. Yeah, I think my learned friend is having this, Milord. This may be the letter. Demand for same and similar facilities. Did you? This is the letter.
Okay. Yeah. Yes, this is the one. Yes, okay. It is there. So they have enclosed this letter at page 44. Okay. Yes. What else?
No, it is just, what was our letter?
Correct, but there, your page 44 letter has been sent with the letter that I was looking for.
Page 44 letter was sent to them,
Yes,
which we gave to the DLC.
yes,
That letter was forwarded to them
yes,
and they were called upon to give a reply,
reply.
and that reply is it.
Our reply is at page 15, 50.
Your reply is such at 46, no?
Again, 46.
46, it's a 46. Your reply is a 46.
Again 50. Yes, 46 first. Again, another reply is
Page
there.
46, then 50,
Then 50 also.
then 50, 54.
50 is with regard to
50
letter dated 10/6/16.
9/7/16.
10/6/16.
Demand for same similar facilities to,
That is other issue.
that is our letter to the Deputy Labor Commission at page 50. And page 52, last 3 lines below your lordships can see. Thus,
Yes,
there is substantial difference between the contract laborers engaged in oil and regular employees of oil in terms of degree of skill, educational and technical qualification, experience, selection process, responsibility, accountability, initiative, reliability, trustworthiness, etc., for which they cannot be judged to be performing the same and similar kind of work. It is not out of context to mention here that in the last recruitment for the post of unskilled labor against the vacancy notification of 315 posts, more than 10,000 candidates appeared.
Yes.
That's the situation. I remember here also the High Court had two posts of cure. About 10,000 applications came. It's an alarming situation.
Yes.
Now, I've read their reply at 46, page 46. You know? 47, 5. 40 page, you also come page 47, 5. Their reply.
47.
Paragraph 5. Put to paragraph, in this connection, we further submit that the basic wage rate under this settlement have been fixed at par with the regular grade workman, depending upon the nature of work and in consonance with the Rule 2525 of the Act, and Well India Limited has been complying the same. Well India Limited is a government company and has to follow the government guidelines, including the sanctioned post prescribed from time to time. We further submit that the list of concerned numbers of contract laborers were made after the various settlements entered in the Central Labor Association, the Central Labor Association unions. The only purpose was to ensure proper discharge of benefits to the wages to these WCLs by the contractors. The list as available with the Well India Limited. The details of the WCLs made subsequent to the memorandum of settlement and are enclosed herein. For your kind reference, all these WCLs are being engaged by the contractors for various miscellaneous workers as instructed by the respective contractors. In this regard, we further like to inform you that OITTS during last year by the name and style of Well India Tika Sramik Jyotha Mantra has started serial protest, blockades, various well installation restraining the movement officials and the official vehicles, etc. Against the OIL with their demands for regularization of Well India Limited, regularization in Well India Limited, and against these demands, the conciliation proceedings are pending before the Regional Labour Commissioner Central Dibrugarh. We submit hearing that these wage contract laborers, WCLs, who are the members of OITTS, TSS, are the party to the settlement in force, and have violated the terms and settlement under which they have been availing various benefits. That we further submit that OITSS pending the conciliation proceeding before RLC Central has filed a writ petition number such and such before the Honorable Guwahati High Court with their demands and affidavit in reply, and has also filed Well India Limited, the same proceedings before the court. In these circumstances, denying the documents, demands, and allegations of OITSS are particularly pending in conciliation proceedings and the outcome of the writ petition before the Guwahati High Court, and we request you to kindly drop the proceeding and reject the demands raised by the session. So what they have not stated anything about that they are not performing.
Kept quiet.
No. Only thing is that they are covered by the WTS and they appeal before the High Court for regularization.
What happened to this writ petition?
They denied having filed it.
Huh?
They have filed this union, but they deny that they have not filed. Yes, page 52 and 77.
Huh? So that is a different, that was the regulation of contract labor. law.
WPC two four six nine. 2469 of 15, that was filed by this union. But before this court, the environment was they didn't file, somebody else filed. And that your lordships will get at page 77.
That is for the regulation. I have not,
No, whatever it is, your conduct in denying is
I have to check.
not correct. As regards the last paragraph of 70, as regards the statements made in paragraph 4, this union would like to state that OITSS has not filed any writ petition by 2469 of 15 in the Honorable Guwahati High Court against Oil India Limited, being the respondent claiming wages and other facilities on the basis of principle of equal pay for equal work. However, OITC would like to make it clear that OIWA, another association, might have filed said writ petition claiming for regularization of the works contracts.
Yes.
And the statements
We have
made
made
are
clear.
true and based on actual
Huh?
facts.
Oh,
And this is
that
the,
would, that define the OI way, or in
No,
your,
no, no, just-
might have filed writ petition. They define.
No, kindly, this is the, we found it below 2469 is filed by Oil India, Tika, Shramik Sangha and two others. And it was disposed of on, I think,
Disposed of on December 19th
1812
as instructed.
as in. But they seem to deny this, which is apparent at page 77. And they said that it is filed by, it may have been
No, no.
filed by somebody else. Page 77, but no.
Yes.
This is your environment.
What they have stated. As regard the statement made in that paragraph, this union would like to state that OITC has not filed any writ petition by number such and that in the Honorable High Court against the Oil India Limited, being respondent claiming wages and other facilities on the basis of the principles of equal pay and equal wages. We have not filed any application for payment of equal wages for equal wages. That might have some intrigue in the word. And this case was for regulation of the workers.
For regular, direct recruitment.
For their case. Again, Jailer Millard. Another letter
Another letter.
was filed by to them at page 50. Here also, Millard, they took the same step, it's a long letter. Here one of the stand is that we filed a writ application, which is covered by the settlement. And contractor is not a major as a party, all these things are here.
Contrary to record, page 52, kindly see.
Yes.
Last 4-5 lines of paragraph 6, at page,
Yes,
50
I have,
at page 52.
yes, yes.
Thus, there is substantial difference between the contract laborers engaged in oil and the regular employees of oil in terms of degree of skill, educational and technical qualification,
Yes.
experience,
That is there.
selection process, responsibility, accountability, initiative, reliability,
I think we
trustworthiness,
need another date.
for which
Mr.
they cannot be
Kapoor.
judged to be performing
Mr.
same or
Kidira.
similar work.
I think we need another date.
Our case has not been started as yet.
Wait, let it be over first. Why are you in a hurry?
Okay, no, so prior to will your case start after the judgment is passed here or it has to be heard? No, no. Your case, can it be disposed of after passing a judgment in this case or has to be heard together?
After this is completed, your
he
lordship can
can
have,
bring-
because you see, Milord, that is
No, he can bring some
overlapping
new
with
point
this.
also, Milord.
Overlapping.
Overlapping, only there will be some additional 1 or 2 points. Because this is covered by this.
You see, the basic thing is basically whether a procedure is required to be followed other than
Some
the procedure
procedure-
made by that person, by
Yes.
DCSE.
Correct.
So
Which is
that
the
is,
basic-
that is the basic thing. And one other thing that might have to be considered is with regard to the addition of the 5,000 and 3,000. Can he do that? Those two aspects. Others, I don't think there's much.
And whether that particular point of time, whether the wages fixed is more than the wages lowest rank of the wage of the grade. Your lordship will see that has not been given. I'll show another idea.
Anyway, I think this will take some time.
It should not take. one.
Uh, I've heard you for how many, 3 times already, I think.
I won't take any chance in predicting.
No, you see, one bunch is, that is the point. Tell them to get that point. On this. Tell them to have the, no, put it in the, no, put it here. Put this like this, no? Okay. Put it here. I will not pass any judgment order. It's, or should I pass some order? Let it go through it. Just say, heard the counsel for the parties. The case of the petitioner is that case of the petitioner is that they could not have, a dispute could not have been raised. Disputes like demand could not have been raised by the respondents during the validity of the conciliatory settlement. Secondly, the contractor should have been made a party prior to the DCL bracket C having issued the impugned order. In terms of Rule 25. Bracket 2, bracket 5, Roman 5, bracket A of the contract labor bracket regulation and abolition bracket close central rules 1971. Thirdly, no notice was issued. Notice was issued.
The procedure adopted is not.
Thirdly,
Giving
no proper procedure was adopted by the DCLC prior to passing the impugned order.
And the contractor point also, you can, logic can, if you can.
I think that's the basic thing. Also,
Contractor and the principal employer. Not.
relevant aspects were not considered. Next para. Mr. A. Das Gupta, learned counsel for the respondent number 3. Submits that in terms of Rule 30,
Section 30.
Section 30. Section 30 of the Contract Labor Bracket Regulation Abolition Act of 1970. The provisions of the Act would be applicable even during the subsistence of a binding settlement between the parties. And as such, there can be no rule to the effect that a conciliatory settlement arrived at between the parties cannot be superseded by an order passed by the DCLC under Rule 25, bracket 2, bracket 5, Roman 5, bracket A of the 1971 rule. He also submits that the Contract Labor Regulation Abolition Act of 1970. Now, the object of such act is to eliminate what the contractual system of engagement.
And if it is not possible, it has to be regulated.
And if the same is not possible, the same has to be regulated.
And Rule 25 is one of such regulatory affairs provision. Whereby
Rule 25 bracket, Rule 25
Rule 25.
of the 1971 rules is accordingly one of the mechanisms to be adopted, one of the provisions to be adopted for regulating contractual engagement of employees. The issues that have to be decided is as to whether, what are the issues to be decided? As to whether a procedure, as to whether the
Procedure
CDLC,
adopted by DLC is fair or not.
whether the procedure adopted by the DCLC is fair or not,
And whether due to that procedure, whether they were agreed by all.
and whether the procedure followed by the DCLC caused any prejudice to the petitioner. That's all. Anything else? No. Just say hurt feelings to all of them. List the matter again. Difficult now. Next week to know. Next week to know. Okay, we do it on the first week of January or second or third week of after Bihu. When do you want?
And your lordship, it is as per your lordship convenience.
Second week. Third week. Okay, list the matter, give a date. Is it too far? There is that Bihu is closed, huh? No. Basically, I've heard everything now.
Everything is over.
Only he has to give me some citations, and then we will start with the second case, which should not take too long. Only thing, my request to you is, please do not give me 3-4 judgments on the same point.
No, I will not, 3 or 4 judgments are there.
Just please write, please give a note, your judgment paragraph, that's all. So whatever I've given you,
Almost
that
practical
is
aspect was
separate,
built.
we'll put it in. Put it in the back of this.
Look, he would like to bind it if it.
Ah. He'll,
He will give it back to him.
yes. We don't want to keep it before Christmas because
No, no.
not even finished. So I'll be having
I
too
don't
much.
want your lordship.
You keep that. Okay, whatever. Yes. Ah.
File binding of notice.
Anything else? Some matters are there? Which are the?
It may fix after vacation nothing.
Item 10, okay, right, on the prayer, the party list the matter after vacation.
Even 7 or 9.
Okay, 7, 9.
Interim may continue. Yeah, the interim.
Interim order to continue, huh? Till the next day. In Mr. Goswami's sheet, interim order.
Item number 15 and 16 also there, after vacation. 23rd of January.
The APDCL matter. What to do? Actually, without thinking, we fixed this case today. And a lot of partner matters we could have, lot of matters we could have decided.
23rd of January.
This is the matter of 23.